Hi, everyone. Maria Gadzek, welcome to this evening's discussion on the restitution of property in Turkey after 100 years. Thank you all for being with us, those who are on YouTube, those who are here in Abajan Hall at St. Leon, and those who are on Zoom. Thank you. Umer Kantik, thank you for being with us from Istanbul. Destina Kantik, thank you for being with us. Aida, thank you very much for accepting our invitation to be our moderator. Aida, for those who are here that do not know, teaches politics at NYU and at Boğaziçi University. She's interested in the politics of post-nationalist historiographies and transitional settings, the political economy of mass violence and state formation, the politics of apology, dignity as a constitutional term, and the recent politics of infrastructure. Erbal Aida is a managing editor of Haytert, which for those who are not familiar with can be seen and can be accessed online at www.haytert.org, which is a multilingual minority news aggregation site in Turkey. She's a published short story writer and one of the founding editors of Azad Alik, which is a multilingual politics blog, primarily dealing with minority issues in Turkey. Aida also occasionally contributes to newspapers and magazines in Turkey and the United States, and she's also a filmmaker, which in her modesty, she omitted from her biography. I'd like to thank all our co-sponsors who are making this evening, as well as many of our evenings, all our evenings possible when we have such discussions. They are AGBU Ararat, the Ararat Eskidja Museum, the Armenian Bar Association, the Armenian Network of America, the Constantinople Armenian Relief Society, KAS, the Daughters of Vartan Saganus Otyag, the Knights of Vartan Bakraduni Lodge, Nasser's Kaust Gulbenkian Foundation Lecture Series on Contemporary Armenian Issues, St. Leon Armenian Church, and Tibravank Alumni Inc. I would also like to give special thanks to our good friend Nuran Besidyan, who initiated and helped organize this evening's discussion. Without any additional delay, I'd like to hand over the discussion to our moderator, Aida. Yes, you can. Please talk, yes, and I'm going to, you can do that now.
Good evening, and thank you, Ara, for inviting for the moderation. So when Ara invited me, I said, can I do like a 10 minutes of recent sources of Armenian and other sort of minorities properties? Sorry. Am I being heard online?
Okay. You are being heard. Just so that all our speakers know, because the weather is awful for those who are not here. It's a crazy rainstorm. It's been raining all day and it's gotten worse over the recent hours. So really, I really thank everyone who's here tonight. And therefore, I didn't have a chance to also tell our moderator and our speakers that we're using these microphones are the only microphones that are working. Everyone must remain muted on the Zoom application throughout the discussion, or else we'll have serious and awful reverberation. Thank you.
Okay. So when Ara told me to moderate, I said, okay, I'm going to present maybe for 10 minutes before I introduce you to our esteemed guests today. So I'm going to talk a little bit about the recent developments. When I say recent, please understand the last 15 to 20 years, because this is recent in Turkish history of developments regarding properties and whatnot. So it did not necessarily start very recent, and Destina and Ömer are going to give a much thorough sort of a story of what happened, when happened. But even as early as 2005, and even earlier than that, Turkish civil society and journalists and academics started to talk about issues of properties, confiscated properties. One article that I clearly remember, which was a radical newspaper, which is a defunct newspaper right now. It doesn't operate, it's sort of closed down, which was a Doğan Group newspaper. Ayşe Hür, who's a popular historian, she's not, at the time, she didn't have a degree yet, but she was writing popular history pieces. She talked about how the Tapu Kadastro, which is the main registry, land registry in Turkey, has been already digitized by 2005, but it was not made available because obviously the state pretty much obviously knew that once it's publicized in a digital format, it's gonna cause a lot of trouble. So therefore, this was never published. But we know for sure that this was digitized by 2005 because she wrote about that, and she then after that she sort of in subsequent years worked on that more and more. So the research side of it was already in place by, I would say, 2005. But this is nothing new if you know a little bit of the Turkish sort of political / literary / academic sphere, because early on, if you were somebody who was a keen reader of Turkish literature, you would know that, for example, in the novels of Yaşar Kemal, but also Kemal Tahir, the properties of Armenians, not necessarily during genocide, but after genocide, had been confiscated and had been sort of given to, in most cases, to their neighbors. So in other words, you would be able to follow the properties of Armenians, the sort of foundations of all properties and whatnot, through literature as well. In other words, you didn't have to really go and do historical research if you wanted to have an inkling to the subject. Then came all sorts of other sort of new historians, among them Ümit Kurt comes to mind, and Uğur Ümit Üngör comes to mind, and of course the work of Taner Akçam and Ümit Kurt, who some of them directly dealt with the property aspect of the losses, but some of them indirectly talked about citizenship aspect and also property aspect of it. So we have an evolution of literature within social sciences, which gave us an ample information, at least a starting information, where we can start and then develop a kind of a research from there on. So I'll show you something. This is not my research, by the way. I do not conduct research on property predominantly. I do other things. But just to give you an idea, here, I'll show you a couple of things that I came across only because I was sort of being on social media. And this is by Ira Turu, who is a Greek historian, Greek-Armenian historian living in Greece at the time. And she realized that the Istanbul University digitized a whole archive starting with 1928, down to 48. Right now they're digitizing more. So when you open these newspapers, which is very interesting, you see a lot of things. You see, for example, that there is absentee property, that they're looking for the, they're trying to sort of take on themselves, or they're trying to basically make sure that these properties do not return to their rightful owners. Or you see, for example, that especially when it comes to communal properties like schools, churches, and other sort of jamarans, etc., these slowly turn into Turkish state government buildings. So this is pretty much, I'm not going to take too much of your time, but just to show you an array of, the newspapers from 28, let's say, to 42, 43, which are the years of the wealth tax, varlık vergisi, which basically where minorities have been heavily taxed, not just Armenians, but also Jews and Greeks, and also dönmes, the converts. So you would see that there's a whole array of day-to-day sort of little newspaper pieces where they announce either take over, or basically there's a court case that they're trying to prove that the rightful owners are really the Turkish authorities and not Armenians or Greeks themselves. So it goes on and on and on. For example, this one says there's a monastery in Heybeliada, in one of the Princess Islands, and it says that the Heybeliada monastery has been taken from the priests and have been given to their rightful owners in this case being the Navy. So it's very interesting, right? So it became a Navy school. So, and this one shows a particular sort of, again, a sort of a whole list of the properties that they're trying to change hands, confiscate. And here you see the name of Azaryan Efendi. Azaryan Efendi is a very famous Armenian in a lot of ways, because he is one of the first people who, not one of the first, the only, I would say, the first person to have an entire plan of a planned county, because Istanbul, remember, Istanbul at this time is pretty much empty, especially the Anatolian side of Istanbul. So he is one of the ones who planned a whole county from scratch by the name of Pendik. Not only that, during Ottoman times, I mean, because this was an Istanbul intellectual, during the times of the invasion of Istanbul, he was one of the ones who supported the resistance, I mean, Turkish resistance. But despite all this stellar sort of and good Armenianness, he could not escape being evacuated and being, disappropriated, I should say. So this is from Milliyet newspaper, 1935. And my last slide is going to be, I mean, this is again another Armenian cemetery court case that is that started in 1932, is going to 1936. This is the Kadıköy Armenian cemetery that took for a while for them to confiscate, but eventually it got confiscated. And this recent thing I saw like 2 days ago, literally, and this is not my research. Again, this is somebody else's readings, and this is an Istanbul University professor, Doğan Gürpınar, who put this online, on Twitter. Of course, with a shame on you. How dare you were able to, confiscate all these properties as if you're doing a slow down? No, because I'm trying to cut down.
That's okay.
Okay.
That's okay.
How dare you just, because the narrative here is such that, let me give you a little background. So the person who wrote this book is the son of Rabbani Tunaman. Rabbani Tunaman is one of the founders, the architects of, or I should say, the masterminds of Turkish National Reassurance, which is the Turkish national insurance sort of authorities. Turkey did not have any competitive national insurance at the time, and as a matter of fact, we learned again from this book that the foreigners made fun of Turkey, saying that you would never have a reassurance society who can compete with international insurance agencies and whatnot, insurance societies. But here, Rabbani Tunaman's son recounts how, based on his father's recounting of all these incidents, that around the time of the wealth tax, Rabbani Tunaman was invited at a sort of governmental level discussion or debate as to what should they do in order to be able to finance the looming World War II. And then, and the decision was already made by the time he was in that meeting. So they tell him that they will levy taxes on minorities. And Dönmez are the convert ones, and Dönmez are not going to be able to escape from this. I'm just going to read a little bit for those of you who know Turkish, because I know we have friends from Turkey as well. I'm not going to read. I'm just going to sort of translate, but give you time so that you can read the text on your own, perhaps. So Tunaman, the father, resists the idea that they should levy these extra taxes on minorities because he says this is going to leave a mark on your face that you're not going to be erased. This is going to be a historical sort of mistake. But notwithstanding, of course, the decision is made. So I don't know to what extent this story is true. It needs to be researched, better. But based on their recounting of what happened is that minorities also got the news that their properties are going to get confiscated or are going to get taxed, super taxed or heavily taxed. So they started selling, stuff. So Tunaman, the father, went into all sorts of casinos at the time, and basically people were selling or were leaving their registers, their the documents. On the table, like in a regular casino table. And supposedly this Tunaman guy gave sometimes 4 times the actual casino value of that property, sometimes 5 times of the actual casino value of that property. So the son explains this as if his father was doing like a service or something, good or better, comparatively speaking, conservatively speaking. To these people whose properties eventually are going to get confiscated or are just going to get heavily taxed. So all in all, I'm trying to say that because of the digitization and because of the fact that there are so many memoirs that have been published in the last 15 to 20 years, sometimes directly by the people who were in charge of varlık vergisi, sometimes by the relatives of the people who were in charge of the wealth tax, that we have ample information that you would not be able to find by easy research, but notwithstanding the information is there. Moreover, we have the court process, which started early on, I would say 1990s onwards, and then it goes into the Turkish, the whole application process with EU and EU requirements and whatnot, that Ömer Kantik and Destina Kantik are going to revisit for us. So that's me for today. I mean, there's a lot of things that I can talk about, but I don't want to take your time too much. And sorry, I was perhaps very fast at the beginning, so I'm going to introduce them and then continue from there on.
Before you introduce, someone asked, what is the title of this book and who is the author?
Okay, it's a good question. I'll type to the chat. Okay, yeah, I'll type to the chat on the chat. I'm stopping the share so that you can.
Okay, excellent.
Okay. So Ömer Kantik, he's an Istanbul-based attorney. He graduated from Dicle University Faculty of Law in 1989 and has been practicing various fields of law since receiving his license in 1991. With more than 30 years of professional experience, he is the founding partner of Kantik and Kantik, a law firm that specializes in matters pertaining to real and personal property, foundations, inheritance, commerce, employment, contracts, administrative law, tax, and other areas of jurisprudence. He's currently involved in more than 100 minority restitution cases with attorneys Destina Kantik and Arda Kantik. And Destina Kantik is a graduate of Harvard Law School, Robert College, and Istanbul University Law Faculty, summa cum laude. And she works on minority issues and matters of commercial law and arbitration. Welcome, both of you. Thank you for coming, and thank you for for this lecture for tonight. So I'll just leave the word to you.
Yıldan sonra Türkiye'de azınlık vakıflarıyla ilgili olumlu gelişmeler hakkında konuşmak için bize bu fırsatı veren tüm sponsorlarımıza teşekkür ediyoruz.
We want to thank all of the sponsors for giving us the opportunity to talk about the positive developments with regards to minorities and minority foundations in Turkey after 100 years.
Türkiye'de azınlık 1924 tarihinde yürürlüğe giren Lozan Barış Antlaşması'na göre yalnızca gayrimüslimler azınlık olarak kabul edilmiştir.
According to Lausanne Peace Treaty, which entered into force in 1924, only non-Muslims were accepted as minorities in Turkey. Okay, thank you. Yes, please.
Azınlık vakıfları, Cumhuriyet öncesinde gayrimüslim Osmanlı vatandaşlarının oluşturduğu hayır kurumlarıdır. Kendi mensupların seçtiği yönetim kurulları tarafından yönetilmektedir. Azınlık vakıfları mevzuatta cemaat vakıfları olarak da ifade edilmektedir. Türkiye'de 77 Rum, 54 Ermeni, 19 Musevi, 10 Süryani, 3 Keldani, 2 Bulgar, 1 Gürcü ve 1 Maruni olmak üzere toplam 167 azınlık vakfı bulunmaktadır. Eski ve yeni medeni kanuna uyarınca belli bir cemaati desteklemek amacıyla vakıf kurulması mümkün olmadığından yeni azınlık vakfı kurulması hukuken mümkün değildir. Günümüzdeki cemaat vakıfları varlığını Türkiye'nin kurucu anlaşması olan Lozan Antlaşması'nda vakıfların korunması öngörüldüğü için sürdürmektedir.
Minority foundations. Minority foundations are charitable institutions created by non-Muslim Ottoman citizens before the establishment of republic. They are also known as community foundations. They are managed by boards of directors elected by the members of each community. There are a total of 167 minority foundations in Turkey, of which 77 are Greek, 54 are Armenian, 19 are Jewish, 10 Assyrian, 3 Chaldean, 2 Bulgarian, 1 Georgian, and 1 Maronite. Since it is not possible to establish a foundation to support a certain community in accordance with the Old and New Turkish Civil Code, it is not legally possible to establish a new minority foundation. Today's minority foundations continue to exist because the funding agreement of the Turkish Republic, the Lausanne Peace Treaty, stipulates the protection of foundations.
Azınlık vakıfları ile ilgili yapılan düzenlemeler. Osmanlı hukukunda vakıfların tüzel kişilikleri ilk defa 1912 tarihli kanun ile edilmiştir. Bu kanun ile ilk defa azınlık hayır kurumlarına taşınmazları kendi adlarına tescil etme hakkı verilmiştir. Türkiye'nin uluslararası hukukta egemen bir devlet olarak kabul görmesini sağlayan Lozan Barış Antlaşması'nda azınlıklar hukuku düzenlenmiştir. 37. maddede bu maddelerin kanunlarla, yönetmeliklerle veya sair düzenlemelerle değiştirilemeyecek mahiyette temel yasalar, les lois fondamentales olduğunu tayin ve tespit etmiştir. Lozan Barış Antlaşması'nın 38-44. maddelerinde azınlıkların özellikle masrafları kendilerine ait olmak üzere her türlü hayri, dini ve sosyal kurumları, her türlü okul ve diğer eğitim ve yetiştirme kurumlarını kurma, yönetme ve denetleme hakkına sahip olduğu ve Türkiye hükümetinin söz konusu azınlıklara ait kiliselere, havralara, mezarlıklara ve diğer dini kurumlara her türlü korunmayı sağlamayı yükümleneceği, aynı azınlıkların bugünkü durumda Türkiye'de var olan vakıflarına ve dini ve hayri kurumlarına her türlü kolaylık ve müsaadenin gösterileceği ve Türkiye hükümetinin yeni din ve hayır kurumlarının kurulması için bu gibi özel kurumlara sağlanmış olan gerekli kolaylıklardan hiçbirini esirgemeyeceği hükme bağlanmıştır. Bu şekilde 1912 yılında tüzel kişilik kazanan cemaat vakıfları anayasal mahiyette uluslararası antlaşma güvencesine de kavuşturulmuştur.
On to the regulations erected with regards to the minority foundations. Under optimal law, the legal personality of foundations was accepted for the first time in 1912. With this law, for the first time, minority charities were given the right to register immovables in their name. The Lausanne Peace Treaty, which enabled Turkey to be accepted as a sovereign state under international law, included the law of minorities with its articles 37 to 44. Article 37 determines that these articles are the constitutive law, la loi fondamentale, which cannot be changed by laws, bylaws, or any other regulations. Articles 37 to 44 of the Lausanne Peace Treaty are entitled Protection of Minorities, and these articles are entitled to constitutional status. Article 40 stipulates that minorities have an equal right to establish, manage, and control at their own expense any charitable, religious, and social institutions, any schools and other establishments for instruction and education. As per Article 42, Turkey undertakes to grant full protection to the churches, synagogues, cemeteries, and other religious establishments. All facilities and authorization will be granted to the pious foundations and the religious and charitable institutions of the said minorities at present existing in Turkey. And the Turkish government will not refuse for the formation of new religious and charitable institutions. Any of the necessary facilities which are granted to other private institutions will be given to the minority foundations also. In this way, community foundations, which gained legal personality in 1912, were also guaranteed by international treaties of a constitutional nature.
1935 Aralık ayında yürürlüğe giren Vakıflar Kanunu'na istinaden 1936 yılında azınlık vakıflarının beyanname vermeleri istenmiştir. Bu beyannameler 1936 beyannamesi olarak anılmaktadır. Beyannamelerde hayra tahsis edilmiş malları, hayratlar ile bunlara gelir getiren malları, akarlar gösterilmiştir. Azınlık vakıfları taşınmaz tüzel kişiliklerin olmaması nedeniyle mal edinemedikleri dönemlerde taşınmazlar cemaatteki güvenilir kişiler adına veya Hazreti İsa, Hazreti Meryem ve melekler adına tescil edilmiştir. 1936 beyannamesi gereği tapuda kayıtlı mülk sahibinin kim olduğuna bakılmaksızın beyannamelerinde beyan ettikleri tüm taşınmazların kendi adlarına tapuda tescil edilmelerine imkan sağlanmış ise de uygulamada oldukça sıkıntılı durumlar yaşanmıştır. Özellikle Hazreti İsa, Hazreti Meryem ve melekler adına kayıtlı olan taşınmazların vakıf adına tescili için yapılan başvurular sırasında resmi kurumlar bu kişilerin kendilerinin veya mirasçılarının gelip imza vermesi istenmiştir. Dikkat edilirse gelip imza vermesi istenen kişiler arasında Hazreti İsa, Hazreti Meryem ve melekler veya bunların mirasçılarıdır. Bunun mümkün olmaması nedeniyle de bazı taşınmazlar sahipsiz olduğu gerekçesiyle resmi kurumlar adına tescil edilmiştir.
Pursuant to the Foundations Law, which entered into force in December 1935, the minority foundations were asked to submit a declaration in 1936. In the legislation and practice, these declarations are referred to as the 1936 declarations. In those, they declared their properties, both the ones assigned to the public service and the ones allocated to provide revenue for the public service. During the periods when the minority foundations could not acquire immovable property under their name, the immovables were registered on behalf of reliable persons in the community and or Jesus, Virgin Mary, or the angels, that is the religion personas. In accordance with the 1936 declarations, all immovable properties declared in their declarations were allowed to be registered in the minorities foundation's name, regardless of whom the owner seems to be on the title deeds. These regulations faced incredible resistance in practice. As per the foundation's law and their declarations, minority foundations made applications to register the immovables in their names. Upon these applications, official institutions asked the seamed owners or their heirs to come into the office and sign official papers for the transfer. Among the people who were asked to come and sign were Jesus, Virgin Mary, angels, or their heirs. Since this was now possible, some immovables were registered in the name of state branches on the grounds that these properties were unclaimed.
Yasal düzenlemenin yanlış yorumlandığını gören Türkiye Büyük Millet Meclisi 1955 yılında aldığı karar ile eski kayıtlardaki kişilerin veya mirasçılar gelmeden de vakıflar adına tescil edilmesi gerektiği belirtilmiştir. Bu düzeltme üzerine bazı taşınmazlar vakıflar adına tescil edilmişken birçoğu edilmemiştir. Tescil edilmeyen taşınmazların bir kısmı envali metruka kanunları çerçevesinde, bir kısmı ise Cumhuriyet sonrasında kayıp şahıslar veya mirasçısız kalan kişiler adına kaldığı gerekçesiyle en basit şekilde idari kararlarla ya da adli kararlarla devlet el koymuştur. Bu kararlarla Tanrı kızı Meryem, melekler ve benzeri kişilerin kaçmış ve mirasçısız vefat ettiğine karar verilmiş oldu. Mahkemelerde açılan davalarda misal Hazreti İsa'yı, Meryem'i ve o zamanın çoktan vefat eden din görevlisini hasım göstererek onlara kayyım atayarak davalar kabul ediliyor ve taşınmazlar idare adına tescil ediliyordu.
Seeing that the legal regulation was misinterpreted by the administrative branches, the Grand National Assembly of Turkey, with its decision in 1955, stated that the persons in the old records or the heirs need not show up and sign. These immovables must be registered in the name of the minority foundations. Upon this correction, some immovables were registered in the name of the minority foundations. However, many were not. In terms of some unregistered immovables, the state confiscated some on the grounds of law on derelict, envali metrike law, and other on the grounds they were in the name of missing persons and heirless persons with administrative or judicial decisions. With these decisions, Maryam, the daughter of God, angels, or others were decided to be among the people who have fled the country or died without heirs. In courts, state would initiate these lawsuits against Jesus, Virgin Mary, or already deceased priests or rabbis, and it would appoint trustees to them and move on with the judgment. These lawsuits were, because there was no one to object to, were accepted, and immovables were registered in the name of the state branches.
Cemaat vakıfları 1936 yılından itibaren 1974 yılına kadar bağış, vasiyet ve satın alma yoluyla taşınmaz mal edinmişlerdir. 1970 yılından itibaren kanunda kesinlikle böyle bir kanuni düzenleme olmamasına rağmen mahkemeler azınlık vakıflarının soru cevap şeklinde doldurdukları 1936 beyannamelerini azınlık vakıflarının vakfiyesi olarak kabul etmiştir. 1936 beyannamelerin düzenlenmesini öngören kanun maddesinin gerekçesinde iş bu beyannamelerin sadece azınlık vakıflarını denetleme amacıyla istendiği belirtilmesine rağmen mahkemelerin bu kabulü azınlık vakıflarının hak ehliyetinin tamamına yakınını ortadan kaldırmıştır. Bu nedenle de azınlık vakıfları 1970-2002 yılları arasında mal edinememişlerdir. Avrupa İnsan Hakları Mahkemesi kararlarında da kabul olunduğu üzere Yargıtay Hukuk Genel Kurulu'nun 1974 tarihli kararı evrensel hukuk kurallarına aykırı mülkiyet hakkının ihlali niteliğindedir. Yargıtay Hukuk Genel Kurulu kararı doğrultusunda azınlık vakıflarının 1936'da verdikleri beyannameden sonra elde ettikleri tüm mal varlığının iptalini talep edilebilir hale gelmiş ve azınlık vakıflarının mal edinme yetkisi geçmişe yönelik kaldırılmıştır. 1974 tarihli Yargıtay Hukuk Genel Kurulu kararı sonrası cemaat vakıflarınca 1936-74 yılları arası bağış, vasiyet ve satın alma yoluyla edinilen taşınmazlar tekrar eski maliklerine iade edilmiş. Bu malların bir kısmı hazine, vakıflar genel müdürlüğü veya üçüncü şahıslara geçmiştir.
Community foundations acquired the immovable properties through donations, bequests, and purchases from 1936 until 1974. Since 1970, although there is absolutely no such legal regulation in the law, the courts accepted the 1936 declarations filled in by the minority foundations as their charters. Although they were in the form of Q&A, and it was clearly stated in the justification of the article demanding the preparation of these declarations, that these were requested only to supervise non-Muslim foundations. This illegal acceptance of the courts eroded the minority foundation's legal capacity and capacity to act. For this reason, minority foundations could not acquire property between 1970 and 2002. As accepted in a decision of European Court of Human Rights, the 1974 decision of the Court of Appeals General Assembly is contrary to the rules of universal law and is a violation of the right to property. In line with the decision of the Court of Law General Assembly, the state branches became able to demand the cancellation of all assets the minority foundations acquired after 1936 declarations, and the right to acquire property of minority foundations was abolished retroactively. After the decision of Court of Appeals in 1974, the immovables acquired by minority foundations between 1936 and 74 through donations, bequests, and purchases were returned to their former owners, and some of these properties were transferred to the Treasury or Directorate of Foundations.
Gerek 1936'dan sonra edindikleri taşınmazların eski maliklerine devredilmesi, gerekse 1936 beyannamelerinde beyan edilen taşınmazların tapuya tescillerinde yaşanan sorunlar ve benzer problemleri çözmek için ilk defa 2003 yılında Avrupa Birliği uyum yasaları çerçevesinde düzenleme yapılmış ve azınlık vakıfların vakfiyesinin olup olmadığına bakılmaksızın taşınmaz mal edinmeleri ve taşınmaz malları üzerinde tasarrufta bulunabilmeleri sağlanmıştır. 2008 yılında yürürlüğe giren Vakıflar Kanunu geçici 7. maddesi ile 1936 beyannamelerinde kayıtlı olup halen tasarruflarında bulunan namı müstahar veya namı mevhumlar adına kayıtlı taşınmazlar ile mal edinememe gerekçesiyle Hazine ile Vakıflar Genel Müdürlüğü'ne geçen taşınmazların vakıfları adına iadesi öngörülmüştür. Her iki düzenlemenin uygulaması esnasında görülen eksikliklerin ve sorunların çözümü için Vakıflar Kanunu'na 2011 yılında geçici 11. madde eklemiştir. Yapılan bu düzenleme ile cemaat vakıflarının 1936 beyannamesinde kayıtlı olan taşınmazları ile sonradan edinilen ve üçüncü şahıslara geçen taşınmazlarına ilişkin mülkiyet sorunlarının çözüme kavuşturulması öngörülmüştür. Vakıflar Kanunu'na 2018 yılında eklenen geçici 13. madde kapsamında kalan mezarlık ve ibadethane vasıflı 55 taşınmazın mülkiyeti 4 Süryani Vakfı'na devredilmiştir.
And on to the new era in Turkey. In 2003, new arrangements were made for the first time within the framework of European Union harmonization in order to transfer the immovables that the minorities acquired after 1936 and to solve the issues experienced at the deed registries to transfer these immovables. It was ensured that the minority foundations could acquire immovable property and dispose of them whether they had charters or not. With Provisional Article 7 of the Law on Foundations, which came into force in 2008, the immovables registered in the 1936 declarations and still in the minority foundations' possessions, as well as the immovables registered in the name of the religious personas or reliable persons, and the immovables that were transferred to the Treasury and the General Directorate of Foundations were envisaged to be returned to their foundations. Provisional Article 11 was added to the law in 2011 in order to solve the deficiencies and problems encountered during the implementation of these regulations. With this one, it was foreseen to solve the property problems of the immovables registered in these declarations and the immovables acquired after 1936 and were transferred to the third parties. The ownership of 55 immovables qualified as cemeteries and places of worship such as churches, monasteries, etc., within the scope of temporary Article 13 in 2018 had been transferred to 4 Algerian foundations.
Vakıfların mal edinmesi. Azınlık vakıfları 1936'dan önce padişah fermanıyla alım, bağış, hibe yoluyla mal edinebiliyordu. 1936 yılından sonra ise alım, hibe, bağış ve vasiyetname ile taşınmaz mal elde etmişlerdir. İş bu taşınmazlar ise 1974 yılına kadar direkt vakıflar adına teşkil ediliyordu. 1936-74 yılları arasında edinilen mallara 1974 yılından 2002 yılına kadar açılan davalarla el konulmuştur. 1974 yılından 2002 yılına kadar ise mal edinememişlerdir.
So, before the 1936 declarations, minority foundations could acquire assets through either by the Sultan's edict, by purchase, or by donation. After 1936, minority foundations obtained immovables by purchase, grant, or through wills. These immovables were registered directly in the name of foundations. These immovables were registered in the name of foundations until 1974. The immovables that were acquired between 1936 and 74 were confiscating starting from 74 until 2002 with the lawsuits that were initiated. They could not acquire property from 1974 up until 2002.
Taşınmazlara nasıl el konuldu? Bu kapsamda ilkin mezarlıklar konusunu açıklamak istiyoruz. 1924 yılında yürürlüğe giren Lozan Antlaşması madde 42.3'e göre azınlıklara ait mezarlıkları koruması gerekirken 1930 yılındaki kanun ile tüm mezarlıkların belediyeye ait olduğu gerekçesiyle azınlıklara ait mezarlıklara da el konuldu. İş bu mezarlıkların birçoğu ne yazık ki mezarlık olarak günümüze kadar gelmemiş, Taksim Elmadağ'da bulunan Ermeni mezarlığında olduğu gibi azınlık vakıfların muvaffakati alınmaksızın mezarlıklarda bulunan mezarlar ya tahrip edilmiş, ya sökülmüş ya da toplu olarak başka yerlere nakledilmiştir. Eski mezarlık alanları belediyeler tarafından satılmış, imar uygulamalarıyla bu alanlar konut ya da ticari alana dönüştürülmüştür. Günümüzde konut ya da ticari alan olarak kullanılan bölgelerde Ermeni, Rum, Yahudilere ait mezar taşlarına yapılan binalarda ya da yayaların geçişi için yapılan yollarda ya da başka maksatlarla kullanılmış olduğuna rastlamak mümkündür. Kartal Surpnişan Ermeni mezarlığının tamamı, Yeniköy Kütlübü Ermeni mezarlığının büyük bir kısmı Müslüman mezarlığına dönüştürülmüştür. Topkapı Ermeni mezarlığının değeri halen tespit edilememiştir.
And the big question, how were the properties confiscated? We want to start with the cemeteries. According to Article 42 of the Lausanne Treaty, which entered into force in 1924, cemeteries belonging to minorities were supposed to be protected. But with the law of 1930, cemeteries were confiscated on the grounds that all cemeteries belong to municipalities. Unfortunately, many of these cemeteries have not survived to the present day as cemeteries. Just like for the Armenian cemetery in Taksim Elmeda, the graves in the cemeteries were either destroyed, dismantled, or transferred to other places in bulk without the consent of the minority foundations. The old cemetery areas were sold by the municipalities, and these areas were converted into residential or commercial areas. It is possible to come across residential and commercial buildings or roads for pedestrians built with tombstones belonging to Armenians, Greeks, and Jewish people. Kartal Surtnishan Armenian Cemetery as a whole and most of Yeniköy Kütüphane Armenian Cemetery were changed into Muslim cemeteries. Topkapı Armenian Cemetery is yet to be found.
Az önce Ayda Hocam'ın bahsetmiş olduğu Kadıköy Ermeni Mezarlığı.
With regards to the Kadıköy Armenian Cemetery that Ms. Ayda Erbal mentioned just minutes ago.
O Kadıköy Ermeni Mezarlığı da yine Belediyeler Kanunu çerçevesinde 1950'li yıllarda İstanbul Belediyesi adına tescil edilmiş.
That cemetery was also confiscated on the grounds that all cemeteries belong to municipalities in 1950.
Yaptığımız araştırmalarda mezarlık olduğunu tespit ettiğimiz alanla ilgili davayı açtık.
We initiated a lawsuit for the property that we have found through our research to what used to be the cemetery area.
İlk derece mahkemesi davanın kabulüne karar verdi.
The first degree court accepted our claim and stated that this property used to be the cemetery and should ödenmek için.
Tapusunu.
And to cancel the deed registry in the name of the municipality.
Şu anda itirazlar nedeniyle dosya Yargıtay'da.
As for the objections of the defendants, it is now before the Court of Appeals.
Umarım taleplerimiz doğrultusunda dava lehimize sonuçlanır.
Hopefully, it will end in our favor very soon. And the deed itself, the property itself will be registered in the name of the Armenian Foundation.
I'm just gonna interject for a second. I guess the court case starts as early as 32, because the newspaper piece that I have says that it started in 32 and then it finalized in 36, the court case, and it says Kadıköy'ün de alt yol ağzındaki eski Ermeni mezarlığı dünden itibaren belediyeye geçmiş ve tabudaki muameleleri ikmal edilmiştir.
Evet.
Belediye burasını arsa olarak parça parça satacaktır. Yani the court case really takes for 4 years. Probably there probably was. I don't know the interim, yani arasını bilmiyorum. Çünkü arada 14 sene var 50'ye kadar. Muhtemelen arada herhalde gitti geldi mahkemede ama ilk decision'ı 36'da yapmışlar. Yani 36'da şöyle deniliyor. In 36 it says that this cemetery is going to be, first of all, chopped, cut into pieces. Like, in other words, it's going to get, I don't know the land registry term. So it's going to be sold separately by piece. So by piece, they have the approval by 36. So I'm guessing, and this is a guess, ignorant guess, because I don't have the newspaper records in between, probably it took them some other 10, 14 years to finalize the actual piece by piece. Yeah. Yani bir kere de olmamış orası, bir kere de değil.
Şöyle bir durum. 1930 tarihli Belediyeler Kanunu çerçevesinde bütün mezarlıklar zaten kanunen belediyelere geçmiş oldu. Tapu yapmasına gerek yok olmadan.
Under the law that was erected in 1930, all of the cemeteries were by law transferred in the name of municipalities.
Bu kanundan sonra belli bir dönem bazı mezarlıklarda tapu işlemleri yapıldı belediyeler adına, bazılarında da yapılmadı. Ta ki kadastro çalışmaları yapılıncaya kadar.
So up until the actual cadastral work to finalize the work of the deed registries, some of the pieces of lands were not actually seen to be in the name of the municipalities, but although they were transferred by law in their names. But with the cadastral work that was carried on, after that, all of the cemeteries were officially registered in the name of the municipality. So even the cemeteries were in the name of the foundations, they could not be used by the foundations.
Tüm Türkiye'deki mezarlıklarla ilgili çalışmalarda kadastro bir dönüm noktası oldu ve o güne kadar tapusu çıkan çıkmayan hepsi kadastro çalışmalarıyla birlikte belediyeye geçti. 1950 yıllarda yanlış hatırlamıyorsam 52 ya da 54 yıllarındaki kadastro çalışmasından bahsettiğimiz tarih. Yoksa 30'da itibariyle zaten geçmiş kanunen.
So what we're talking about is by 1930, it was transferred as per the law, but with the cadastral work, if I'm not mistaken, between 1952 and 1954, the actual official work was carried out and it was in the name of the municipality officially. So what we're talking about is it was confiscated officially in 1950s, but of course it was confiscated way before that.
Ayrıca o bölgede zaten yaptığımız araştırmada bölgenin tamamı mezarlık ve Rum mezarlığı da var. Rum mezarlığının olduğu yerde binalar var. Ermeni mezarlığının olduğu yerde de kısa bir süre öncesine kadar kafeteryalar vardı. Hiçbir bina yapılıp satılmamış yani tespitlerimize göre.
As we have found out through our research that all that village used to be a cemetery. There was also a Greek cemetery in that area. And on top of the Greek cemeteries, there are now a couple of buildings. But as for the Armenian cemetery area, it has not been sold or was anything built on it. So that was why we were able to get the property deed itself back in the name of the foundation. As contrary to getting the compensation paid.
Diğer taşınmazlar. Dini tesis alanları olan sinagog, kilise, havra, şapel, okul, hastane, yetimhane, çeşme ve diğer tüm kamuya hizmet amaçlı taşınmazlara ve gelir getirici akar taşınmazlara da kısmen el konulmuştur. Bir kısım hayrat taşınmazlar ilgili azınlık vakıfların adına tescil edilmiştir.
Some of the religious facility areas, synagogues, churches, chapels, schools, hospitals, orphanages, fountains, and other immovables for public service and the properties for revenue were also confiscated. Some of these immovables for the public service has been registered in the name of the relevant minority foundations.
1936 sonrası elde edilen taşınmazların el konulması. Azınlık vakıfların 1936 yılında verdikleri beyannamelerde daha sonraki yıllarda satın alacağı, kendisine hibe edileceği ya da vasiyet edileceği taşınması bilmesi, tahmin etmesi ve 1936 yılından yıllar sonra elde edeceği taşınmaza ait bilgileri beyannamesinde belirtmesinin imkansız olduğu açıktır. Azınlık vakıfları tahminde bulunmadıkları ya da 1936 yılından sonra da mal edineceklerini 1936 beyannamesinde belirtmedikleri ve bu nedenle mal edinme hakkının olmadığı gerekçesiyle hibe edilen veya bağışlanan tüm taşınmazlar eski sahiplerine iadesi amacıyla resmi kurumlar tarafından mahkemelerde yüzlerce davalar açılmış, Yargıtay Hukuk Genel Kurulu kararı doğrultusunda taşınmazlar eski sahipleri adına tescil edilmiştir. Azınlık vakıflarının tüm itirazları da kabul edilmemiştir. Taşınmazların eski sahiplerinin bir kısmı mirasçısız öldüğünden veya bulunamadığından taşınmazlar hazineye ya da vakıflar genel müdürlüğü adına tescil edilmiştir. Azınlık vakıflarının parasını ödeyerek satın aldığı, misal Tuzla'daki Ermeni kampı, Kamp Ermen, Bomonti Mıhtaryan okul binası gibi taşınmazlar eski sahiplerine iade edilirken satın alma sırasında azınlık vakıflarının ödemiş oldukları paralar azınlık vakıflarına iade edilmemiştir. Vakıf bir mal topluluğudur ve mallarını işleterek kişilere yardım eder. İş bu haksız hukuki yorum ile vakıfların hak ehilliyeti tamamen engellenmiş ve azınlık vakıflarının özü yok edilmek istenmiştir.
How the properties were confiscated after 1936. It is impossible for minority foundations to know or to state the properties in the 1936 declarations that they were yet to acquire after 1936. Hundreds of lawsuits were filed in courts by the state branches for the cancellation of all immovables donated or bequeathed to the minority foundations, back to their owners on the grounds that the minority foundations did not make any predictions or stated in their declarations that they would acquire property after 1936, and therefore did not have the right to acquire property. The immovables were registered in the name of the former owners, donors, or heirs. None of the objections of the minority foundations were accepted. Since some of the former owners of the immovables died without heirs or could not be found, the immovables were registered in the name of the Treasury or on behalf of the General Directorate of Foundations. While the immovables purchased by the minority foundations, such as the Armenian camp in Tuzla, Kamparmen, Bomonti Mkhitaryan School Building, will return to their former owners. The money paid by the minority foundations for the purchase was not returned back to the foundations. The foundations are collections of properties and help people by operating their goods. With this unfair legal interpretation, the rights of foundations were completely blocked and the essence of minority foundations was tried to be destroyed.
Şimdi de 2002 ve sonrası döneme bakalım. 2008 yılında yürürlüğe giren yeni vakıflar kanunun iptali için Türkiye'de siyasi bir parti Anayasa Mahkemesi'ne dava açmıştır. Anayasa Mahkemesi'nin 17 Haziran 2010 tarihi 2008'e 22 esas 2010'a 82 karar sayılı kararında özellikle söz konusu vakıfların taşınmaz mal edinmelerinin yargı kararlarıyla engellenmesi sonucunda karşılaşılan sıkıntıların bertaraf edilmesine yönelik olduğu şeklindeki gerekçesi Anayasa Mahkemesi'nin ve dolayısıyla yasa koyucunun geçmişte azınlık vakıflarına yönelik hukuka aykırılıkların olduğu ve bu aykırılıkların ise özellikle yargı kararlarıyla yapıldığı açıkça kabul edilmiştir. Kararda söz konusu düzenlemenin kamu yararı ilkesi gözetilerek yapıldığı anlaşılmaktadır denilmesi de oldukça önemli olup azınlık vakıfları ile ilgili yapılan düzenlemelerin kamu yararı düzeyinde kabul edildiği anlaşılmaktadır. Azınlık vakıfları hakkında çıkarılan her düzenlemeden sonra Türkiye'deki siyasi parti yasal düzenlemenin iptali için davalar açmış ise de Anayasa Mahkemesi'nin vermiş olduğu 3 ayrı karar ile iptal taleplerinin reddine karar vermiştir. Dolayısıyla iptal başvurusunun reddine karar verilmesiyle birlikte azınlık vakıfları lehine getirilen düzenlemeler bugüne kadar yürürlükte kalmıştır.
2002 and after, a political party in Turkey filed a lawsuit to the Constitutional Court for the annulment of the new foundations law, which came into force in 2008. In the decision of Constitutional Court dated 2010, it is stated, it is aimed at, these regulations are aimed at eliminating the problems encountered, especially as a result of the prevention of the acquisition of immovable property by the mentioned foundations by judicial decisions. Constitutional Court, and therefore the legislator, expressly accepted that there have been unlawful violations against minority foundations in the past, and these violations were made by the judiciary. In the decision, it is stated that it is understood that the regulation in question was made by considering the principle of public interest. It is also very important to say that the regulations regarding minority foundations are seen at the level of public interest. Although after each regulation regarding the minority foundations, the political party in Turkey filed lawsuits for the annulment of each regulation, the Constitutional Court decided to reject each annulment request with 3 separate decisions. Therefore, with the decision to reject the application for annulments, the regulations in favor of minority foundations have remained in effect until today.
Yeni Vakıflar Yasası'nın Türkiye Büyük Millet Meclisi'nde görüşülmesi sırasında Türkiye Büyük Millet Meclisi Adalet Komisyonu 25 Ocak 2008 tarihli kararında özetle 8 Mayıs 1974 tarihli Yargıtay Hukuk Genel Kurulu ilamının 2002 yılındaki kanunla ortadan kaldırıldığı, 1936 beyannamelerinin sadece mal beyanı olduğu ve vakfiye olarak kabulün mümkün olmadığı, cemaat vakıflarının Lozan Antlaşması madde 42 gereği tekrar diğer vakıflarla aynı konuma getirildiği, ne vakfın ne de mal varlıkların özüne dokunulamayacağı, aksinin iddiası Lozan Antlaşması'na, Avrupa'nın İnsan Hakları Sözleşmesi'ne, anayasa maddelerine aykırı olacağına karar verilmiştir. İş bu karar üzerine 5737 sayılı kanun geçici madde 7 ve 11 yürürlüğe sokulmuştur. Türkiye Büyük Millet Meclisi kararında ise Lozan Antlaşması'nın 42. maddesinin 3. fıkrasında Türkiye Cumhuriyeti Lozan Antlaşması'yla Osmanlı hukuk düzeninin eseri olan ve o tarihte yürürlükte bulunan şer'i hukuk esaslarına göre kurulan cemaat vakıflarını belirtilen koşullarla koruma ve diğer vakıflarla eşit işleme bağlı tutma yükümlülüğü altına girmiştir denilmiştir.
During the discussion of the new foundations law, which erected the restitution for minorities at the Grand National Assembly of Turkey, the justice community stated that the Court of Appeals decision in 1974 was abolished with the law dated 2002. The 1936 declarations were only declarations of property, and it was not possible to accept them as charters. And the minority foundations were brought back to the same position as any other foundation in accordance with the Article 42 of the Treaty of Lausanne. It is stated that neither the essence of the foundation nor its assets can be touched. The claim to the contrary is the violation of Treaty of Lausanne, European Convention on Human Rights, and Turkish Constitution. Following this decision, provisional Articles 7 and 11 of Foundations Law were put into force. In the Grand National Assembly of Turkey decision, it is stated, as per the third paragraph of Article 42 of the Treaty of Lausanne, the Republic of Turkey, with the Treaty of Lausanne, is under the obligation to protect the minority foundations and treat them as equal to the other foundations, which were the work of the Ottoman legal order and were established in accordance with the principles of Sharia law in force at the time and with the conditions specified.
Her şeyden önce belirtmek gerekir ki, aşama aşama çıkarılan ve taşınmaz iadesini düzenleyen mezkur kanunlar ile kanun koyucu, 1936 beyannamesinde zikredildiği halde el konulan ve sonrasında da mal edinememe gerekçesiyle el konulan taşınmazlar yönünden belirli yasal şartlar getirerek bu şartların mevcudiyeti halinde mülkiyet haklarının veya karşılık değerlerinin iadesi hususunda bir ratio legis'e sahiptir. Bu da kanun koyucunun son dönemlerde yaptığı hukuki düzenlemelerle değişik suretlerle kanuni, idari ya da kazayı yollarla el konulma işlemlerin hukuka uygun olmadığını zımnen kabul ettiğini ve bu sebeple haklarını iade etme yöntemini gösteren bir iradeyi ortaya koyduğu açıktır. Hakların iadesi yönünde yapılan her hukuki düzenlemenin yetersiz kalması üzerine daha geniş kapsamlı ve mağduriyetlerin tamamını giderme amaçlı yeni hukuki düzenlemelerin yapıldığı da görülmektedir. Geçmişte yaşanan hukuki hataların hukuki güvenlik ilkesini ihlal ettiği açıktır. Kanun koyucu yaptığı son düzenlemelerle hukuki güvenlik ilkesini eskiye şamil olmak üzere yeniden tesis etmeyi de amaçladığı açıktır. 2002 ve sonrasında yürürlüğe giren yasal düzenlemeler ile 1924 yılında yürürlüğe giren Lozan Antlaşması hükümlerinin bir kısmı ilk kez uygulanmaya başlanmış olup Türkiye Cumhuriyeti tarihinde azınlıklar için oldukça önemli bir aşamadır.
First of all, it should be noted that as per the aforementioned laws, which were enacted gradually, regulating the restitution, the legislature brought certain legal conditions for the restitution of the immovables, which were confiscated even though they were mentioned in the 1936 declarations, and which were confiscated for the reason of not being able to acquire property. That is, the legislator has a ratio legis for the return of the property itself or the payment of compensation values. It is clear that the legislator tacitly accepts that the confiscation by legal or administrative means is not in accordance with the new regulations, and it determines the will to reinstitute property rights. It is also seen that new legal arrangements have been made with the aim of eliminating all grievances, which are more comprehensive after every legal arrangement made for the restitution of rights that became inefficient after a while. It is clear that legal mistakes in the past violated the principle of legal security. It is also clear that the legislator aims to retrospectively reestablish the principle of legal security with the latest regulations it has made. The legal regulations that came into force in 2002 and later, and some of the provisions of the Lausanne Treaty, which came into force in 1924, were implemented for the first time, which is a very important step for minorities in the history of Republic of Turkey.
İadeler. 2002 yılında çıkarılan kanunlar çerçevesinde azınlık vakıfların yapmış oldukları başvurular neticesinde Vakıflar Meclisi'nin almış olduğu idari karar ile 365 adet taşınmaz mal azınlık vakfı adına tescil edilmiştir. 2008 yılında yürürlüğe giren kanunla 181 adet taşınmaz mal vakfı adına tescil edilmiştir. Ayrıca 150 adet taşınmazın tapuda isim tahsisi yapılmak suretiyle mülkiyet sorunu çözümlenmiştir. 2011 yılında yürürlüğe giren kanunla 333 adet taşınmaz malın azınlık vakfı adına tesciline, 21 adet taşınmaz için ise bedel ödenmesine karar verilmiştir. 2018 yılında yürürlüğe giren kanun kapsamında kalan mezarlık ve ibadathane, vasıflı 55 taşınmazın mülkiyeti 4 Süryani Vakfı'na devredilmiştir. Yukarıda belirtilen düzenlemeler ile 2003-2018 yılları arasında toplam 1084 taşınmaz malın cemaat vakıfları adına tesciline, 21 taşınmaz malın da cemaat vakıflarına bedelin ödenmesine karar verilmiştir.
Restitution. As a result of the applications made by the minority foundations within the framework of regulations dated 2002 and onward, in 2002, 365 immovable properties were registered back in the name of minority foundations with the administrative decisions taken by the Council of Foundations. In 2008, 181 immovable properties were registered in the name of the foundations, and moreover, the ownership problem was resolved by correcting the names of 150 immovables in the title deeds. In 2011, 333 immovable properties were registered in the name of minority foundations, and the price for 21 immovables were decided to be paid. The ownership of 55 immovables qualified as cemeteries and places of worship were transferred to 4 Argian foundations in 2018. Between 2002 and 2018, with the above-mentioned regulations, it was decided to register a total of 1,084 immovable properties in the name of minority foundations and to pay the price of 21 immovable properties to them.
Dava süreci. 2002 yılından itibaren yapılan idari başvuruların bir kısmının olumsuz sonuçlanması üzerine azınlık vakıfları yargıya başvurmuştur. Yüzlerce dava açılmış, bir kısmı sonuçlanmış iken bir kısmı ise devam etmektedir. Yargı yoluyla taşınmazların bir kısmı azınlık vakıflarına tescil edilmiş ya da bedellerin azınlık vakfına ödenmesine karar verilmiştir. Bazı davaların olumsuz sonuçlanması üzerine 2010 yılında yapılan anayasa değişikliğiyle 2012 yılından itibaren Anayasa Mahkemesi'ne bireysel başvuru hakkı kullanılmıştır. Anayasa Mahkemesi bireysel başvuruların bir kısmı için olumlu karar verirken bir kısım başvurularda ise bireysel başvuru hakkının 2012 tarihinde getirildiğine, bu davaların ise çok daha öncelerine dayandığına, bu nedenle de zaman bakımından yetkisiz olduğuna gibi gerekçelerle bireysel başvuru taleplerinin reddine karar vermiştir. Anayasa Mahkemesi'nin olumsuz karar vermesi üzerine Avrupa İnsan Hakları Mahkemesi'ne bireysel başvuru yapılmıştır.
On to what we do, the judiciary process. After the negative results of the administrative applications made since 2002, the minority foundations started to apply to the courts. Some of the immovables were returned through the judicial process. The legal procedures continued intensely, and upon the broad interpretation of the legislation by the Court of Cassation, it was decided to return many immovables or to pay the price through the judiciary. Following the negative outcome of some of the cases, the right of individual application to the Constitutional Court has been exercised. The a few of the cases that are still before the Constitutional Court. In a few cases, the Constitutional Court has decided that the rights to individual application was introduced in 2012, and these violations date back much earlier. Therefore, the court decided that it was not authorized to make any decision due to lack of jurisdiction in time. Upon these decisions, we made our applications to the European Court of Human Rights.
Türkiye, Avrupa İnsan Hakları Mahkemesi'nin zorunlu yargı yetkisini 1990'da kabul etmiştir. Avrupa İnsan Hakları Sözleşmesi'nin 1 nolu protokolünün 1 nolu maddesinde mülkiyet hakkına yer verilmiştir. Taşınmazların iadesi için bazı azınlık vakıfları Türkiye mahkemelerine başvurmuş, ancak olumlu sonuç alamayınca Avrupa İnsan Hakları Mahkemesi'ne başvurmuştur. Bu kararlar Fener Rum Patrikhanesi, Bozcaada Rum Kilisesi, Surpırgıç Ermeni Hastanesi, Büyükada Rum Yetimhanesi ve Türkiye'dir. İş bu kararlarda en çok öne çıkan durum ise Avrupa İnsan Hakları Mahkemesi'nin çıkarılan tüm kanuni düzenlemeleri, yaşanan sosyal ve hukuki süreçler kapsamında geniş yorumlaması olmuştur. Avrupa İnsan Hakları Mahkemesi'ne göre cemaat vakıfları 1 nolu protokolün 1 nolu maddesi Lozan madde 42 ve yeni kanunlar uyarınca öncesinde kendilerine ait olduğunu herhangi bir belgeyle kanıtladıklarında kendilerine iade veya mümkün değilse tazminat bedellerinin ödenmesine karar verilmesi gerekmektedir. Az önce ifade edilen Türkiye Büyük Millet Meclisi tutanakları, Anayasa Mahkemesi'nin gerekçesi nazara alındığında 2002 ve sonrasında yürürlüğe konulan yasal düzenlemelerin konuluş amacının bazı davalarda yeterince nazara alınmadığı, mevzuatın ulusal üstü ve ulusal mevzuata, Avrupa İnsan Hakları Mahkemesi kararlarına uygun bir şekilde yorumlanmadığı da görülmüştür. Yasaların konuluş amacına bakıldığında bazı davalarda mevzuatın dar yorumlanması nedeniyle azınlık vakıfları aleyhinde kararlar verilmiştir.
Turkey accepted the mandatory jurisdiction of European Court of Human Rights in 1990. The property right is included in the Article 1 of Protocol No. 1 to the European Convention on Human Rights. In accordance with the laws enacted in 2002 and onward, some non-Muslim foundations apply to the Turkish courts for the return of their immovable properties. But when they could not get results in their favor, they applied to the European Court of Human Rights. These decisions are Fener Greek Patriarchate, Bozcaada Greek Church, Surpırgıç Armenian Hospital, Büyükada Greek Orphanage versus Turkey. The most prominent effect of these decisions is the European Court of Human Rights' wide interpretation of all legal regulations enacted. It examines the articles within the scope of the social and legal developments in Turkey for minorities. According to the European Court of Human Rights, if non-Muslim foundations can prove that a property belongs to them with any document, the property must be returned, or if it is not possible to pay compensation pursuant to the Article 1 of Protocol No. 1, Lausanne Treaty Article 42, and the new laws. When the mentioned decision of the Turkish Grand National Assembly and the reasoning of the Constitutional Court are taken into account, it is clear that some courts, national courts, did not take the purpose of the new legal regulations enacted in 2002 and onwards, the international legislation, and the European Court of Human Rights decisions into account. In some cases, decisions came out to be against the minority foundations due to narrow and erroneous interpretation of the legislation. And with regards to these cases, we are applying to European Court of Human Rights.
Şimdiye kadar hep vakıfları anlattık. Şimdi ise biraz şahıslardan bahsedelim. Başta belirtmek isterim ki iş bu gelişmeler özel kişilerin davalarında da olumlu etkisi olmuştur. Şahıslara ait mal varlığına el konulmasının el-mali metruke kanunları ve Cumhuriyet sonrasında kayıp şahıs, mirasçısız ölme gibi sebeplerle olmak üzere iki ayrı ana grupta değerlendirmek mümkündür. Şahısların mallarına el konulmasına uygulanan yöntemler birbirinden farklı olduklarından iade süreçlerinde uygulanacak hukuki süreçler de farklı olmaktadır. Şahısların malların iadesinde önemli olan mal sahiplerinin mirasçılarının ortaya çıkmasıdır. Vakıflarda olduğu gibi burada da mümkün ise taşınmazın mirasçılar adına tescilline veya mümkün değilse tazminat bedellerin ödenmesine karar verilmektedir.
So far, we have always talked about foundations. Now let's talk about individuals. At the outset, I would like to point out that these developments have had a positive impact on the lawsuits of the private individuals as well. It is possible to evaluate the confiscation of property belonging to individuals into two main groups, namely the laws on derelict, which is envali metruke, and after the establishment of the Republic, confiscation on the grounds that such properties were in the name of missing persons or deceased without an inheritance. Since the methods applied in the confiscation of property of individuals are different from each other, the legal processes to be applied in the restitution are also different. The important thing in the restitution of property of individuals is the emergence of the heirs of the real owners. As in the foundations, it can be decided to register the immovable in the name of the heirs, if possible, or to pay compensation if not possible.
Sorunlar bitmedi. Yeni düzenlemeler Türkiye ve azınlıklar için oldukça olumlu olmasıyla birlikte sorunların tamamen bittiğini söylemek mümkün değildir. 2002 ve sonrasında yürürlüğe giren her yasal düzenlemenin kapsamının bir önceki yasal düzenlemeden daha geniş bir durum kapsaması nazara alındığında yasa koyucunun iradesinin olumlu olduğunu, geçmişte yaşanan hukuka aykırılıkların tamamını çözme iradesini gösterdiğini söylemek gerekmektedir. Mevcut mevzuatın yeterli olmadığını gören irade, mevzuatın kapsamını daha da genişleteceğini düşünmekteyiz. Hukuka aykırılık sürecinin geçmiş süresi, hukuka aykırılık hallerinin oldukça çeşitli olması göz önüne alındığında, çıkarılan mevzuatın bazı hukuka aykırılıkları kapsamadığı düşünülse dahi, mahkemelerin yasaların konuluş amacını nazara alarak ve mevzuatı geniş yorumlayarak da bu sorunu çözebileceğini düşünmekteyiz. Sabrınız için çok teşekkür ediyorum.
There are still issues to resolve. Although the new regulations are very positive for Turkey and the minorities, it is not possible to say that the problems are completely over. Considering that the scope of every legal regulation that came into force in 2002 and onward covers wider restitution than the previous one, it should be noted that the will of the legislator is positive and shows the will to solve the unlawfulness experienced in the past. Seeing that the current legislation is not sufficient, we think that the legislation will further expand in scope. Considering the past duration of the illegality process and the wide variety of illegalities, we think that even if the legislation does not enact a more comprehensive regulation, the courts can also solve this problem by interpreting the legislation broadly by taking into account the purpose of the law. Thank you for your patience.
Thank you, Destina. Thank you, Ömer. I'm going to now open the floor for discussion and questions. How should we do this? Should we take the questions from the audience, Zoom audience first, and turn here? How do we do this? Because there's a bunch of questions that were posted online when you were speaking. So I'm going to go read them, and then I'll take the questions from here if you don't mind. Okay. Okay. So David Boyajian has a question. Regarding Armenian-owned businesses confiscated after the Armenian genocide, especially larger businesses, do we have a record or paper trail of what happened to them, such as to whom they were sold or transferred? I ask because it is said that some large Turkish businesses down to the present day were built on the confiscation of Armenian businesses. Çevireyim mi ben? Ha. David Boyacan şey soruyor. Ermeni soykırımından sonraki özellikle büyük iş diyebildiklerimiz, yani büyük sanayi veya büyük ticari mal mülk olarak bildiğimiz şeylerin bir takip edebileceğimiz bir, yani kağıt üstünde takip edebileceğimiz bir şeyi var mı? İzleri var mı? Bunları nereden bulabiliriz? Çünkü şimdiye kadar bazı Türk büyük ticari işletmelerinin Ermeni mülküne Ermeni mülküyle kurulduğu iddia ediliyor. Bunlar konusunda nasıl bir yol izleniyor? Bir şey var mı? Yani bir iz tutturabileceğimiz bir iz var mı diye soruyorum.
Şimdi kişiyi kendisini ilgilendiren veya ailesini ilgilendiren bir husus var ise zaten muhtemelen elinde de bir takım belgeler vardır.
Zannederim onu sormuyor. Daha çok yani izini süremediğimiz ama diyelim ki uydururum şimdi yani beş kardeşler diyelim, beş kardeşler Elazığ'dı değil mi? Beş kardeşlerin bulunduğu yer neyse. Hani onlar gibi böyle yerelde çok iyi bilinen aileler var. There are families which we know like sort of I should say not famous but prominent families, that's the term. Prominent families with businesses in the locales like Elazığ, Adana, elsewhere in Dikranagerd, etc. Whose businesses we know, they were big business owners and their properties also were confiscated. So I guess David's question is more about their properties with or without their families claiming the properties, whether there's a paper trail attached to this.
Arşivleri yani %100'üne ulaşmak belki mümkün değil ama uzmanlık gerektiren bir husus arşiv araştırması da, çünkü özellikle bahsedilen ticari şirketleri ya da mal varlığıyla ilgili genel bir araştırma tamamen uzmanlık gerektiren bir husus ve muhtemelen de rastlamak mümkün değil. Belki %100'üne rastlanmasa da rastlanabilecek şeyleri olacak.
Ben bir şey söyleyeyim. Bununla doğrudan alakalı değil ama zamanında Abdullah Gül'ün Dışişleri Bakanı olduğu zamandı zannedersem. Tam hatırlamıyorum. 2006 yılında olsa gerek bu. Bu konuyla ilgili değil ama İsrail-Filistin'le ilgili Hamas seçimlerinden sonra Hamas'ın bir şeyi gelmişti. Ne derler ona? İki dil arasında şimdi çeviremiyorum kendimi. Birileri ziyarete gelmiş İstanbul'a. Bayağı eleştirmişlerdi. O zaman şöyle demişti Gül. Yani ben ilgilenmeyeceğim de kim ilgilenecek? Biz zaten geçen sene yani 2006'dan bir sene önce oluyor 2005'te Filistin'in bütün tapularını kendilerine hediye ettik. Yani bütün buraların tapuları bizim elimizde. Yani biz biliyoruz kimin malı vesaire. Dolayısıyla yani, tabii ki bu konuların içinde biz olacağız demişti. I'm going to translate for you. I basically said that even though this is not directly related to that, it's related to a kind of a parallel history between Israel and Palestine. And in 2006, I cannot remember what he was exactly, whether he was the Ministry of Foreign Affairs or at the time president, cannot remember off the top of my head, but Abdullah Gül, upon a visit by Hamas to Istanbul, he said that of course they're going to come here, of course we're going to be the mediators of this whole process, because we have, technically speaking, all the deeds for Palestine as well. And as a matter of fact, he said, we gave them, we basically gifted Palestinians of all the entire sort of deed collection for Palestine. So of course, it goes without saying, all these documents do exist, but to what extent they are reachable, to what extent they are searchable, to what extent they are, accessible, that's a different topic.
Bir şey ekleyeyim bu hususa. Bundan yaklaşık belki 8-10 ay önce Kudüs'teki Ermeni Patrikhanesi'nin Kudüs'teki taşınmazlarıyla ilgili yapmış olduğu bir belgeyi Ankara'da Arşiv Dairesi'nde bulup götürüp orada işleme koydular. Bütün evraklar bir şekilde ulaşılabiliyor yani.
All of the archives in Turkey are actually accessible. Of course, it might not be accessible 100%, but the research through the archives is an expertise, and we use those experts to do our research, and we eventually find the documents that we need. For example, the Patriarchate, the Armenian Patriarchate in Jerusalem, had a list of documents with regards to the properties in Jerusalem that was found in Ankara archives. And they found it in the archives and sent it to the Jerusalem Patriarchate, and they're actually moving forward with that list in Jerusalem.
I'm going to add one more thing, because Destina talked about it during her speech. She gave the example of Gezi Park, which was a Surpagop cemetery to the border of Gezi Park. And sometimes you can remember at the beginning of my very fast talk, I don't know how much you were able to follow me because I was extremely speedy in order to be able to give them the time. But now I can comment on that. Sometimes researchers have all sorts of other, side documentation or side memoirs, which may not necessarily directly documents or memoirs of Ottoman authorities. For example, case in point, when Istanbul was under occupation, there was a British governor, Charles Harrington, and in his memoirs, Harrington talks about how he is the one, and he brags about it. He is the one who raised down the ground the Armenian cemetery for the first time. Because he was a soccer fan and he wanted to use the cemetery for soccer, tennis, and cricket tournaments. So the first time that the Armenian cemetery had been used as something other than cemetery was done by British and not Turks. So they carried the tombs and whatnot to another location, but this was done when Istanbul was under British occupation. So there's all sorts of, if you are a historian, if you are an area specialist or the era specialist, there are all sorts of side documentation that you can find, then you can figure out when exactly the cemetery ceased to become cemetery. Then of course Turks take over, the Turkish Republic takes over, and the court process goes the way you just narrated, in the 30s onwards, and Armenians are not able to get it back, unfortunately. Türkçesini söyleyeyim mi? Okay, yeah.
So if you can use the microphone. Yeah. This way, those on Zoom will also hear you.
Yeah, hi. On a more practical level, so I understand as an individual, if I have a general idea that perhaps my grandfather, great-grandfather owned property, is it a matter of just going through the archives? Can I do a search by last name? Do I go to the municipality where the village is from? Let's say it's in Adana or Kars or whatever, or is it all centralized in Istanbul?
Çok genel araştırmayla başarılı olabileceğini sanmıyorum. Çünkü neticede bir devlet veya o dönemdekiler bir el koyma olmuş ise bunlar da zaten bir şekilde gizleniyor. Buradaki en iyi çözüm
What we have seen so far is that a general research at the archives is not going to end up in your favor, because during those times it was the confiscation time, and they erased their tracks along the way.
Yani ya mirasçıların torunlarının ellerinde bir belge olması ya da en azından yerini bilmesi, tarif etmesi halinde dahi orada tarif edilecek yerden bile eski kayıtlara ulaşmak mümkün.
So the heirs should either have a documentation, or if they know the exact place, if they can give directions to that place, it's enough. Then we can point out which land that we're going to have to go through the archives for.
Yani yaklaşık 100 yıldır üzerinden geçen süre zarfında sokak isimlerinden tutun da mahallelerin isimleri, her şey değiştiğinden eski bilgilerle çoğu zaman ulaşmak da çok güçleşiyor bu.
Because it's been 100 years and the street names changed, the neighborhood names changed, and with the fires, even the structure of most of the neighbors changed. So it is hard to find through a general research.
Bir de tabii Türkiye'de bazı yerlerde, İstanbul'da mesela yangınlar çok olmuş. Hatay'da nüfus kayıtları, tapu kayıtları yanmış. Ülkenin muhtelif illerinde bu tür yangınlar da olduğu için kayıtlara ulaşmak bazen çok güçleşebiliyor.
In some areas, there were fires at the archives. And for example, in Hatay, most probably half of the archives were lost. So we need something to start with.
Yeah, so there is no, because you said you were digitized. That's why I thought maybe.
Oh no, it's not reachable by regular people. The digitization.
I know. That's why if you hire somebody like a law firm, for example, that could do the research, not me going and on computer, but like a law firm researching it.
Araştırma yapılabilir ama başarı şansının düşük olduğunu söylemeye çalışıyoruz.
We just wanted to point out that the chance of a success is low. Of course, that's what we do. We have a lead. When we have a lead, we go through all the archives, and if we find it, we can pursue it.
Yani araştırma için herhangi bir hukuki bir engel yok.
There's no such legal or administrative block or interference from the government to go through the archive. So it is in our leisure to go and do the research.
Yes, please.
Oh,
Well,
can I just
actually,
take one more
Yes,
question
take
from
one
here?
question from Zoom,
Okay,
and then-
so
and
I'm
then-
going to take one more question from Suren Shahinyan. Actually, this is a similar question. Do you know if there is a general law in Turkey for its citizens or their legal descendants to claim their private property lost in the result of the First World War, military activities, i.e. as a result of their dislocation, death for descendants, etc.? Thank you. So is there a law that such research can be based?
Var. Normal mevzuattaki kanunlar şu anda bütün mirasçılar gibi azınlık vatandaşlarının da mallarını almasını engelli bir durum yok.
Even though let's say the said citizen does not have any citizenship.
Tabii ki hiç sorun yok.
So what he said is that of course there is law for the restitution of the individual persons. Even the basic law of Turkey is actually in favor of the restitution for individuals' properties. And even though they're not citizens, they can make their claims under the Turkish national courts.
Yani dava açabilmek, hakkını alabilmek için Türkiye Cumhuriyeti vatandaşı olmasına gerek yok. Mirasçı olması yeterli.
There's no need for someone to claim their rights to be a citizen of Turkey. They just need to be the heirs of the owner of their property.
Let's take this question.
Okay. Benim English or Turkish?
Whichever way you want.
Okay. I found out what I read about the Incirlik Air Force Base and also the Sis Catholico set and the presidential palace in Ankara. They are all on Armenian land or Armenian property. Is there any action being done? I know Sis Catholico set did that, but they weren't successful. Could you just tell us some more about those situations? Or
Would you like to
cases?
hear a specific case?
Hmm?
Would you like to hear about a specific case?
Yeah, those three of them. If there's
Oh.
anything.
Oh,
going-
developments. So you said Incirlik, Ankara, and
And the Catholico set of Sis.
Siz Adana, tamam.
I know Sis, they made a case,
Anladım,
but it
Kozan'dan
didn't go
bahsediyor.
through or something was
Kozan'da.
legally
Yeah.
not correct, so.
O üç şeyle ilgili diyor bir gelişme var mı onları merak ediyorum diyor ama hani ayrıca bir dava ister misiniz diye soruyorum. Sadece bununla ilgili merak ediyorum.
Şimdi İncirlik davası ile ilgili bir girişimde bulunuldu ama çok başarılı olduğunu duymadık. Başarılı olduklarını görmedik, yani duymadık.
O buradan mıydı, Türkiye'den miydi?
O
Onu...
buradan olmuştu ama Türkiye'den herhangi bir yansıması olmadı.
as for the base in Incirlik, there was a lawsuit initiated from here, and as we heard, there was no in favor actions coming up soon.
SİS'teki yerle ilgili olarak da Türkiye'de dava açıldı.
As for the Sis property, a lawsuit was initiated under the Turkish law in the Turkish courts.
Dava ilk derece mahkemesince reddedildi.
The first court refused their claim.
Çünkü o reddedildi ve şu anda itiraz aşamasında.
Now, of course, it's upon onto the next degree of courts. It has been appealed.
Muhtemelen Avrupa İnsan Hakları Mahkemesi'ne kadar bir süreci var.
Probably they have a way up until the European Court of Human Rights.
Cumhurbaşkanlığı
In
Ankara'daki Cumhurbaşkanlığı Köşk'ün mirasçıları Türkiye'de yaşıyor bir kısmı. Bunu biliyoruz.
Some of the heirs of the property in Ankara
Kasapyan.
are still Kasapyan family are still some of the heirs are still living in Turkey.
Some in Canada, I believe.
Hı?
Bazıları da Kanadalılar
Evet.
galiba.
Yani bu tamamen mirasçıların vereceği karara göre dava açıp açmayacakları.
So it depends on the heirs to initiate the lawsuit or not.
Sizin hukuk bürosun nerededir? İstanbul'da yoksa?
Şişli'de,
Şişli'de.
İstanbul'da.
Şişli.
İstanbul'da.
Hı.
Ve sizin aslınız nereli?
Adıyaman.
Adıyaman. Teşekkür ederim.
Ben teşekkür ederim.
Thank
Sağ olun.
you. I'm gonna ask the next question from Zoom. Gonca Sönmezpool is asking, what are the state or conditions of the returned properties currently? What are they being used for? Who's taking care of them? And what shape are they in?
İlk onların taşınmazların durumuna ilgili.
I have a question.
Yeah, next you are.
Next.
You are next.
Rotating between Zoom
We are
and.
rotating between
between Zoom
online
and
and
here.
yeah.
Okay,
No, no,
my
no, there's still a question being
wife's
asked.
family came from Connecticut, did diabetic care.
One sec. It will be the next question. It will be the next question.
Okay.
Devletin el koyduğu taşınmazlardan bahsediyor değil mi? Yanlış anlamadıysam.
Şimdi geri verilenlerden bahsediyor.
Ha, geri-
Return
Tamam.
properties. Yeah.
Geri verilenler Türk bahsetmiş olduğumuz 167 vakıf yönetim kurulları tarafından idare edilmektedir. Aralarında onlar yönetiyor.
The immovables that were returned back to the minority foundations that we have listed, which are of 167 of them, they are using their properties for the good of the public, for their community, Armenian community, Jewish community, Greek community, and all the 9 minorities.
I'm going to ask a follow-up question for Gonja's question. Are there any sort of side cakes or kicks from all these negotiations that you know of? Yani şimdi bunlar geri veriliyor ama şartlı şurtlu mu veriliyor? Yani bir
Hayır.
kısmı.
No. There's
So,
there's
okay.
no nothing on the deeds, nothing on the money that is given. It's free of every charge and everything.
Şu var. Bir taşınmaz, iade edilen taşınmazın tapusu veriliyor ise, istisnasınız var, veriliyorsa ve bu taşınmaz 1936 beyannamesinde kayıtlı ise, yasal düzenlemeye göre sizin onu satmanız için mahkemeden onay almanız gerekiyor. Aksi halde siz vakfı yok etmiş olacaksınız. Onun için vakıflar için öngörülmüş bir düzenleme.
There's one exception just for the minorities, not individual people, is that if the foundations, minority foundations, want to sell or dispose of a property that is listed in their 1936 declarations, they need to get a permission from the court because it would mean to hurt their presence as a foundation.
Bu aynı zamanda vakıf yöneticilerin keyfi uygulamalar yapmasının da önüne geçmiş oluyor.
This regulation is aimed at controlling the board of members from doing anything that is irrational and is not in the favor of the foundation.
Siz haklı gerekçeler sunduğunuz zaman mahkemeler genelde satış yetkisi veriyorlar.
And the courts generally give permission to sell the properties when reasonable reasoning is presented.
Thank you.
Thank you. John, please.
My wife's family came from diabetic care through Cuba and also America. She owned property in diabetic care. She has the deed for the airport in diabetic care is her property.
Oh my God.
She gave it to a Turkish lawyer. She gave it to a lawyer in Boston, and all they took was money and no results. We waited 100 years. Do we have to wait another 100 years? What's going on? What makes you think there's going to be restitution now? I don't understand why everybody's getting excited. We have the deed and it's no avail. Explain that.
Yani şimdi başka bir avukatın takip ettiği bir dava ile ilgili çok konuşmak istemem.
We would not make much of a comment on a case
Biliyorsun.
that another lawyer is pursuing.
But
But what is the but here?
Ama normal koşullarda o davayı çünkü bildiğim için yani çünkü çok bir şey de yorum da yapmak istemiyorum işin doğrusu. Kelimeleri özenle
So this is
seçmek
not
istiyorum.
finalized. Huh? It's still continuing. Devam ediyor. hala.
bu dava.
Bildiğim kadarıyla evet.
Okay.
As we know of, the case is still
Kendileri de
ongoing.
biliyor.
were you familiar with this case? Had you heard of it?
Yes,
Oh, you
yes,
had heard of this case?
yes, yes.
I see.
Hı hı.
Okay.
Yani
Biliyoruz
onu
bu davayı.
Okay, so,
biliyordum.
all right.
And because it's just another lawyer and another lawyer's case,
Yes.
it would be unprofessional.
Let me ask this. I think there was a slide that noted that 1,084 properties have been recovered.
Yes,
of these properties, how many are outside of Istanbul? How many are within Istanbul? And how many were first confiscated prior to the formation of the Republic? If I can get just an idea. Huh?
It's a very complex question. I don't think you're gonna have.
Ve hangisi Cumhuriyet öncesi ve sonrası?
Bunların
Best guess. I mean,
büyük
I mean,
çoğunluğu
obviously.
%80'i İstanbul'da.
80% of the 1084 mumuls are in Istanbul.
Which is not the bulk, of course. There's more in Anatolia.
Of course, of course.
Yani bunların büyük bir kısmı da 36 beyannamesinde kayıtlı olan Cumhuriyet öncesinden gelen yerler.
And most of these properties were listed in the foundation's declarations, 1936 declarations. So these properties were owned by them during the Ottoman Empire.
Bu idari yollarda şey yapanlar, davayla alanlar.
Tabu idari yollar. 1084 idari yollar.
So, and we just wanted to make sure that it's understood that 1084 immovables were just given back
Davalar
by
hariç.
administrative decisions. That is not the judicial process.
I
With
see.
the judicial process, it's more.
How many times, I mean, do we have an idea as to how much more?
Sayısal bir şey verir misin? Ne kadar daha fazla verilmiştir diye.
Yani biz yüzlerce dava açtık.
Well, we initiated more than 100 cases. So you can actually, even think of the greater number of the properties.
Mhm.
Ciddi alanlar ve ciddi miktarlara ulaşacağını tahmin ediyoruz.
We estimate that it's going to end up in real serious, ample amount of properties and value.
Mhm.
I have another question online.
Please.
This is from Avo Gazal. Does the number of lawsuits mentioned earlier include properties or lawsuit by the Armenian Patriarch of Jerusalem, of the Catholicos, or of Cilicia? Do you have a status on them?
Kudüs'teki Katolik şeyle ilgili dedi ki yani mallarla ilgili herhangi bir bilginiz var mı? The properties in Jerusalem or in Turkey?
No, the lawsuits by the Armenian Patriarch of Jerusalem, of the Catholicos, or the Catholicos of Cilicia.
Onların işte davayla ilgili bilginiz var mı? Yani Kudüs'teki bir Katolik.
In Antibes.
I mean, Avedis is asking the question, yeah.
Okay.
Avedis, there is a correction to your question by Nurhan Becidiyan. You have to talk to each other.
O Beyrut'taki bakın şeyde Patrikliği'den bahsediyorum.
I think the of should be an and.
Ha,
I think
Beyrut'taki işte
Even
Kilik-
Yes.
Kilikya. Evet. Sis diye bildiğimiz bir bölge. Burada dava açıldı, az önce de ifade ettim. İlk derece mahkemesinde davalar reddoldu. Şu anda itiraz aşamasında olduğunu biliyoruz.
What we know is that their claim at the first degree court was refused, but they appealed. So it's up to the Court of Appeals decision.
Is that with regard to the patriarchate? Or
Yes,
the,
Patriarchate
or the,
insists.
Okay. We got, okay.
Okay. I mean, there is a Jack Essenian question which you already answered. Can you start a lawsuit if there is no deed of the property? You said that you can, technically speaking, it's going to be a cumbersome process, but you can.
Yes, you can.
You can hire a lawyer in Turkey. And Sarkis asks, what is the current situation of Camp Nubar and the Bomonti Mkhitaryan School, of which I'm an alumnus?
Oradan mezun olan şey sorulmuş Mkhitaryan binası.
Mkhitaryan and Camp Nubar.
Ve oradaki kamp falan şey evet oradaki binaları söylüyor.
Kamparmen Ermeni cemaati tarafından 1936 yılından sonra satın alınan bir yer. Daha sonra
Kamparmen property is one of properties that was bought by the Armenian foundations after 1936.
Gedikpaşa Ermeni Protestan Kilisesi Vakfı'na bağlı bir yer.
It belongs to Gedikpaşa Armenian Protestant Church Foundation.
Bu daha sonra taşınmaz mal edinmesinin yasak olduğu gerekçesiyle yine satan kişilere iade edilmişti.
So after the 70s, as we explained with the judicial misinterpretation of the law, it was canceled. That was the property's deed registry was canceled, and it was registered back in the name of the heirs and the owner that actually sold the property to the foundation.
Daha sonra bu iade süreçleri başladığında taşınmaz üçüncü kişi adına kayıtlı olduğundan yasal mevzuat gereği iadesi mümkün değildi.
So at first, under the regular Turkish law, because the property was in the name of the third parties, it was not possible to get the title of the property back.
Çünkü üçüncü şahsa iade dedikten sonra birkaç kez el değiştirmiş şahıslar.
Because it was when it was transferred to the third parties sold to other third parties, and third parties sold to other third parties. So it changed hands.
Bütün hukuk sistemlerinde olduğu üzere tapuya güven ilkesi çerçevesinde iadesi mümkün görülmedi. Ancak
Under the Turkish law and under the principle of trust to the deed registry, it was not possible to cancel the deed and re-register it in the Gedikpaşa Armenian Foundation's name.
siyasi irade oluşan Türkiye kamuoyunda oluşan durumu nazara almış ve özel bir çözüm ile eski 8.000 küsür metrekarelik alanın yaklaşık %60'ını vakfa iadesine sağlamıştı.
So it was through the politics that the property was actually given back. The Turkish government took into account the public's view on the subject, and they, with the administrative decision, they gave back 60% of 8,000 square meters of the area that was used to be compartment back to the foundation.
Kalan kısmın da iadesi için halen çalışmalar devam etmektedir.
The rest of the property that was not reinstituted, the procedure on that is in still continuation.
Biz bu vakfın avukatı da olduğumuz için bu bütün süreci yakından takip ediyoruz, biliyoruz.
Because we also represent this Gedikpaşa Foundation, we closely examine the situation and we closely follow what's happening.
Mkhitaryan'da Pangaltı Mkhitaryan mı, Bomonti Mkhitaryan mı?
Bomonti. As far as I understand, it's like Bomonti Mkhitaryan.
Bomonti Mkhitaryan davası başka bir avukat arkadaşımız tarafından yürütülüyor.
Bomonti Mkhitaryan Buildings lawsuit has been handled by another lawyer.
Ancak bütün detayları biliyoruz.
But we know all of the details.
Bu taşınmazla ilgili tüm süreç olumsuz sonuçlandı Türkiye'de.
The legal procedure ended negatively for the foundation at the national courts.
Şu anda Anayasa Mahkemesi'nde süreci devam ediyor.
The process before the European Court of Human Rights is still continuing.
Anayasa Mahkemesi işi kabul edilebilir gibi görüp incelemeye başlamış.
European Court of Human Rights decided that it was a matter that they should make an examination on it, so they started to examine it by the judges.
Anayasa Mahkemesi'nden gelecek olumlu sonucu bütün Ermeni Katolik cemaati ve Mkhitaryanlar bekliyor.
I'm sorry, my mistake. I said European Court of Human Rights, but it's actually Constitutional Court. My mistake. Excuse me, I've been interpreting for a long time now.
The next question is by Felipe Mkhitaryan. I'd like to know where I could even find information on the property my grandmother's family had in Maraş. I was told he hosted statesmen, officials, and he was some type of government bureaucrat.
Benim ailemde yaşamıştım. O zamanlarda bir siyasi vermiş, hatta orada siyasi görevini doldurmuş. Onların mallarının meselesini bulabildim.
Yani belge olması çok önemli. Belge olunca da bir şekilde ulaşabileceğini düşünüyoruz.
Even with the smallest document or knowledge or information that the elderly in the family have, it's enough to pursue the lawsuit. So we need to start with a lead. If we have the lead, we can continue and find it.
Suren Shahinyan has a question. Are you aware of any successful cases of reclaiming property by Armenian? You mean individual, Suren? I cannot tell. Suren, individual properties you're talking about? Suren, if you can type, if you are here still with us, and if you can type, on the chat, Suren Şahinyan. Suren, if you're here, if you can please type your question in a more detailed manner. I'm going to go to the next question. How can I claim my grandfather's properties in Sivas and Samsun who perished in 1915 genocide?
Birincisi mirasçısı olduğunu ispat etmesi gerekiyor.
First of all, we need to establish that this person is the heir of that family, of the owner of the property.
İkincisi de malları tespit etmesi gerekiyor.
Secondly, we need to detect which properties belong to the great parents.
Sonra bunların nasıl elden çıktığını tespit edip hukuki süreci ona göre başlatmaları gerekiyor.
And lastly, we'll discover how the properties were confiscated, and then we will be initiating lawsuits.
Okay. Scott Zekian has a question. He says, if I understand this correctly, as long as we have our deeds, there will be restitution at some point, correct?
Eğer elimizde tapular varsa belli bir zaman içerisinde illaki bir ödeme ya da bir mal değerlendirme alacağız.
Büyük bir olasılıkla alır.
Most probably, yes.
Okay. Antoine Cenanci has a question. Do you recommend any lawyer for the restitution of our properties in Turkey, Mardin and vicinities, which are estimated to have an area of approximately 500 kilometers square? Oh my God.
Bizim işte malum bir 5 metre böyle bir alanımız var. Bir avukat tavsiye edebilirsiniz.
Well, I would respond that this is the work that the Kantik and Kantik law firm
Biz o işte-
takes on.
Evet.
Yeah.
Çok cevap vermek istemiyoruz.
Sean Talebian has a question. What is the process for individuals to go about finding restitution if they have in their possession paperwork? I mean, we answered this question earlier. If there's proof of ownership of properties, it's easier, as far as I understand. And what would be the first step for those families to take? Hire a lawyer. So that's the first step. And eventually you may get them back, hopefully.
Suren has a question. Yeah.
Okay, Suren,
If I
yes.
may.
Sorry.
Well,
I'll ask a couple of practical questions. First of all, can you please explain to us the terms of your engagement? Do you take the cases on contingency basis, on a retainer basis? That's first question. Second one, can you please give us a lay of land in Turkey in terms of the legal representation? We understand based on your presentation that you have been engaged in 100 or so cases. Are there other players? Are you focusing or specializing in any particular area of this type of lawsuits versus the other players? Who are the other players? And anything else about the legal landscape specifically for the restitution of Armenian properties? And also throwing also there your connection to the Armenian community and Armenian foundations, if you may. Thank you.
I'm going to start with the last one and build up to the others.
Şimdi ilk başta şey söyleyeyim. Böyle şeyleri hallediyorsunuz. Üstelik mi alıyorsunuz? Yoksa aylık ödeme mi alıyorsunuz? Yoksa psikoloğa mı alıyorsunuz? İkincisi, sizin işinizde başka avukatlar da var mı? Siz neye odaklanıyorsunuz? Siz hangi işinize bakıyorsunuz? Ne yapıyorsunuz? Üçüncüsü de sizin oradaki Ermeni cemaatiyle ve vakıflarıyla olan ilişkiniz nedir? İstersen tersten var.
Evet, bizim Ermeni cemaatiyle ilişkimiz Ermeni vakıfların yaklaşık 30'una yakın avukatıyız.
We represent 30 of the minorities, Armenian minority foundations in Turkey.
Cemaatle de ilişkilerimiz iyi.
We have good connections with the Armenian community.
Patrik Hazretleri ile de sık görüşüyoruz.
We are common visitors of the Patriarchate in Istanbul.
Özellikle cemaati ilgilendiren konulardaki süreçleri birlikte yürütmeye, birçok kişiyle birlikte yürütmeye çalışıyoruz.
We try to manage the problems of the Armenian community as a team together from the people within the community.
Bizim çalışmalarımız hem vakıflar hem de şahıslarla ilgili davalarımız da oluyor.
We represent foundations and also individuals.
Yani şunu söyleyebilirim ki biz bir davayı almadan önce kazanma ihtimali yoksa başta araştırıyoruz. Kazanma ihtimali yoksa onu açıkça söylüyoruz. Ne kendimiz sürece giriyoruz ne de kimseyi umutsuz bir bekleyişle bekletmek istemiyoruz.
So when we take on a case, actually before taking on anything, we do our thorough research and we detect the possibility of success. And if we actually believe that the case can be resolved in the favor of the foundation or the individuals, then we take on the journey. If not, we do not want to waste our time or the people's time or their hope along the way.
Ücret konusunda ise her davanın niteliğine göre taraflarca konuşulup belirleniyor. Onun için bir yol belirtmek mümkün değil.
As for the attorney fees, it depends on the case and it is always discussed with the client and it is settled with the client depending on the type of case.
Oh, I'm gonna take one more question from here and then come back to the hall. So Hagop asks, we have deeds of properties, pieces of land and shop that were registered in the main register in the name of our grandfather before 1915. Can we claim now, or is it preferable to wait for new, more favorable regulations for abandoned properties?
1915'ten önce Adnan'la olan taşınmazlar varmış. Şimdi mi davalar açmalıyız yoksa sonrasında için yeni düzenlemeleri mi beklemeliyiz diyor.
And
Saçlar için fark etmiyor mu? Onu kaçırdılar bence.
And if I may ask also, and if you do take action now and you are not successful, if the laws become more liberal, do you have the opportunity to again
Yeah.
advance
So
a
there's
case?
one more question
If I
like
can
that
ask
towards the end. I mean, we have 10 or 12 more questions. One of the questions was that if, let's say, there was in the here and now, if there was a bad case which did not give any results, can you reapply with a new lawyer? Or when the law gets better, this is another question.
Dava açtı, kaybedildi. Yeni bir kanun çıktı ve o daha geniş bir alanı kapsıyor. Onunla ilgili tekrardan dava açabiliriz.
Yani sonuçta evet. Çünkü yeni dava açması, yeni bir kanun hak tanımış ise yeni çıkarılacak haktan yararlanıp dava açma imkanları var.
For the second question, yes, it is always under the Turkish law, people can always reclaim under a new law. So if a new law is erected and gives a wider restitution option, then the people can reinitiate their cases.
Çünkü önceki karar, önceki düzenlemeye uygun verilmiş. Yeni düzenleme kapsamında yeni hakla dava açabilir.
Under the new regulation, it means there are new rights and the people can reclaim their rights under the new rights.
İlk soruda şeydi.
İlk soru neydi? Onu
İlk
unuttum.
soru neydi?
İlk soru şeydi, bir dakika. Or is it preferable to wait? Yeah.
Şimdi mi açalım yoksa yeni düzenlemeler için mi?
Tamam. Şimdi öncelikle hukuki durumunu tespit etmeleri gerekiyor dava açmadan önce. Hukuki durumlarını tespit edecekler. Şu anda mevzuatta uygun hükümler var ise dava açmaları gerekiyor. Yeni yasal düzenlemeleri beklemelerine gerek yok. Eğer mevcut yasal düzenlemeler açısından dava açma hakları yoksa o zaman beklemekte faydaları vardır.
So what people need to do at first is to examine what they have and it's in with the order of the law that are in force at the moment. If yes, then they should initiate immediately to get a result in the near future. But if not, then they should wait for the better provisions.
Okay, another question is by.
Hello.
Oh, okay, sorry. Go ahead.
Yeah, this is really a personal question. About 5 years ago, I gave Denise Darmanyan 3 deeds of property in Sivas. Are you handling that? Do you know the people who are handling it? You seem to know about other lawyers who are involved in these cases.
Who did you
Also,
say that you gave it
We didn't
to?
understand.
Denise Darmanyan.
Deniz
Oh.
Dermanyan.
Deniz Darmanyan'a zamanında 3 tane taşınma tapusu vermiş Sivas'ta. O davayı siz mi ilgileniyorsunuz yoksa kimle ilgilendiğini biliyor musunuz?
Deniz mi?
Daha bizim tanıştığımız Deniz mi?
No, it's not one of the cases that we're handling.
Belki de eşi
You
vefat etti,
seem,
o
but you
bir
seem
şey.
to be aware of cases that are being handled by other attorneys. I was told that they're concentrating mostly on properties in Istanbul, and they're sort of ignoring properties elsewhere. Is that the case, or is it more widespread?
Bilmiyoruz.
We honestly, we do not know.
You
We
don't
don't know specifically about your case.
And my last question is, do you handle cases outside of Istanbul, or
Yes,
you do?
yes, we do, of course.
Would there be a conflict of interest if I switched?
Well, we haven't worked together, so professionally, no.
Okay, thank you.
Anahid Uğurlayan has a question. Are there still delays? Sorry. Anahid is asking, are there still delays in returning confiscated properties sold to third parties? And if not, how many have been returned?
For individuals?
As far as I understand, I don't know, Anahid, can you clarify? Are you asking about community properties or individual properties? If you can clarify, Anahid, if you are here.
And the question is about how much.
And the question is
confiscated-
basically, are there still delays in returning confiscated properties sold to third parties? And if not, how many have been returned?
Okay.
She says both communal and individual.
Hem vakıflarla hem özel kişilerde üçüncü kişilerde edilen taşınmazların geri dönüşünde herhangi bir açıklama vesaire oluyor mu? Herhalde bunlar tazminat şeyi karşılıyorlar. Anlaşılmamız gerekiyor.
Taşınmazlar devlet elinde ise ve koşulları oluşmuş ise aynen iadesi mümkün. Tapularını iade ediyorlar. Eğer üçüncü kişilere geçmiş ise de vakıflarda da gerçek şahıslarda da hiçbir sorun yok. Aynı şekilde o taşınmazların dava açtıkları tarih itibariyle belirlenen parasını alabilirler.
So we need to clarify that if the property is in the name of the state, then they can get the property itself back. As that is getting the title deed back in their registered back in their names. But if they're registered in the name of the third parties, if it's sold, if it's donated, or etc., then you get the compensation of the property. And this compensation value is calculated on the date you initiate your lawsuit on.
And does that valuation include lost time? Or is it just based on the current value now?
Hani dedi ki
For instance, lost income if it was an income generating property, let's say.
davanın açıldığı zamandaki değeri hesaplıyoruz. O arada kaybedilen geliri isteyebiliyor muyuz diyor. Yani ecrimsel mi soruyor?
Ecrimsel mi soruyor?
Aynen.
Onu çok istemiyor çünkü o zaman o çok tavsiye ettiğimiz bir yöntem değil. Çünkü orada isteseniz bile o zaman geçmişteki değeri üzerinden bir hesaplama yapılabiliyor. O zaman da geçmişteki kuruş üzerinden bir faiz yürüttüğünüzde bugünkü güncel değere ulaşması zaten mümkün değil.
So we do
Bu
not.
nedenle bugün açıldığı tarih itibariyle değerin tespit edilmesi, istenmesi daha uygun.
So we do not actually prefer to go down that road because it means that if we want the money for the lost time, it means that we're actually taking into account the value of the date it was confiscated, and the confiscation dates, date much earlier, and the Turkish lira used to be in kuruş. So when you get that value that is back in the time, then you do not even get the value that is the property itself is worth at the time that you initiate the lawsuit, that is the current value. But you get the interest as of the date of the lawsuit that you initiated until the date it is paid to you.
You want to add something?
No, thank you.
Okay.
Faizi ne kadardır?
So somebody asking for the Zoom audience, somebody asking,
Faizi
what's the
Yıllık
interest?
%9 şu anda.
It's 9% per year right now.
Kümülatif.
Hayır.
No,
Ana para üzerinden.
yeah.
There's another question which says, are you able to carry out your incredible work without fear of being criticized or somehow punished?
Bu inanılmaz işinizi yaralanmadan veya size zarar vermeden devam ettirebiliyor musunuz?
Ne?
Bu inanılmaz yaptığınız işi size zarar gelmeden devam ettirebiliyor musunuz?
Evet, devam ettirebiliyoruz. Çünkü biz neticede mevcut yasal çerçeveler içerisinde yasaların tanınmış olduğu hakları kullanarak yapıyoruz.
Yes, we are able to continue our work because we're doing work within the legal frame and we're using the rights that is given by the legislature.
There's an interesting question, which also includes issues of citizenship. The person says, Suran actually says, I would like to learn about a most recent successful case of Armenian individuals claiming their property, and also would reclaim property also entitle the owner Turkish nationality if requested.
Diyor ki bir Ermeni vatandaş olmayan bir Ermeni'nin malını geri almasıyla ilgili bir örnek verebilir misiniz? Bir de bu kişi orada taşınma verilmezse ondan sonra vatandaşı talep edebilir mi?
Ermeni olmayan biri mi?
Türk vatandaşı olmayan biri. Türk vatandaşı olmayan Ermeni birisi.
Ha.
Taşınmazını talep etmesiyle onunla ilgili bir davayı vesaireyi açıklayabilir misiniz?
Tamam.
Bir de sonrasında Türk vatandaşı isteyebilir mi?
Bir Ermeni ve Türkiye Cumhuriyeti olmayan ancak mirasçı olan herkesin dava açabileceği açık. Burada Ermeni olabilir, Rum olabilir, Yahudi olabilir veya başka milletten de olabilir. Bunlar herkes dava açabilir. Bunda herhangi bir sorun yok. Taşınmazı edindikten sonra taşınmazın bulunduğu konum açısından önemli bir istisnai bir durum var. Sen devam et.
Everyone, the heirs of the owner of a property can always initiate a lawsuit. It doesn't matter if they're Jewish, if they're Greek, if they're Armenian, and whether or not they're Turkish or citizens or not.
Türkiye Cumhuriyeti vatandaşı olmayan bir kişinin adına tapu tescil edildiğinde taşınmazın bulunduğu bölge, askeri güvenlik bölgesi, devlet açısından özel önem taşıyan bir bölge ise bir sene içerisinde bu taşınmazını satması gerekir.
So, with regards to the types of properties, there's an exception. If the property in question is important for a military cause or that is somehow important to the Turkish government for any public specific, of course it's specified in the law, but especially for the military, if it's important, then it is required for the new owner to sell that property within 1 year if the owner is not a Turkish citizen.
Taşınmazın özel durumu yok ise istediği sürece de onun adına kalabilir.
If the property is not under a special status, then the owner can own the property for as long as he or she wants.
Vatandaşlık ise vatandaşlık kanunu çerçevesinde koşulları oluşmuş ise taşınmaz edinip edinmemesi arasında fark olmayacak.
So, and it won't matter under the law for the citizenship to request citizenship.
So with or without property, you can still request Turkish citizenship. But property is going to probably facilitate things.
Malın olsa da olmasa da Türk vatandaşlığı isteyebilirsin.
İsteyebilirsin
Of
tabii.
course, of course.
Okay, I'm going to ask maybe one more question.
You can ask one more. This gentleman has one more
Okay.
question also.
Can I ask just a new question because
Yeah,
it's
ask a
only
new
the second question? so-
Okay, ask
yeah.
a new one, yes.
Okay, can you hold for a second? Because this is your second round, there are people who are asking first round questions, that's why, sorry. For individual properties, what kind of timeline from the time you get the deeds in your hands plus genealogical tree proof of relationship until a final settlement is found on average?
Diyor ki yani bu bizim size tapuyu verdiğimiz andan itibaren yani daha doğrusu insanın sonrasında andan itibaren malın alınması veya paranın ödenmesine ne kadar süre oluyor diyor. Sadece dava sürecinde değil, sonrasındaki araştırma sürecinin içine koyuyor ve sonrasındaki para ödenmesine koyuyor.
İşte dava açma süreci aslında bu davalar açısından en önemli husus dava açma süreci. Dava açmadan önce yapmış olduğunuz çalışmalar.
The most important thing about these lawsuits is the preparation for these lawsuits.
Dava açmadan önce iyi bir araştırma yapmazsanız davanızın olumlu sonuçlanma ihtimali de oldukça düşük olacaktır.
So you need to prepare, you need to be greatly prepared before the initiation of the lawsuit in order for you to have a great chance of success.
Bu nedenle dava açmadan önceki süreç tahmin ediyorum 6 ile 8 ay arası çoğu zaman sürebilir.
The preparation for the cases takes up probably between 6 to 8 months.
Bu kısalabilir, uzayabilir.
It can, of course, it can be shorter than this or longer than this, but it is the approximate timetable.
Dava açıldıktan sonraki bütün süreç ise tahminen 5-6 yıl sürer.
And from the start of the initiation of the lawsuit until, it goes through all the judicial system, all the, courts of 3 degrees, and until the title is in your name or the compensation is in your bank accounts, that will take approximately 5 years.
Okay, Avedis Ghazal has a follow-up. He says, for foreign citizens, the court of military authorities has to decide. Is that the case?
Yabancılar için askeri işinin izin alınması gerektiği diye bir şey onların dava açabilmesi için. Askeri, değil mi?
Yeah,
Askeri-
the court or military authorities must decide. Either the court or the military authorities have to decide for foreigners.
azınlık yabancıların Türk vatandaşı olmayanlar dava açabilmesi için mahkemelerin veya askerinin karar vermesi gerekiyormuş onlar dava açabileceğini. Bu doğru mu diyor?
Askeriyle bilgisini duymadım bugüne kadar.
There was no link whatsoever with the military so far.
Sadece
If it's of course not a strategic location, I guess.
Yes, but that is
But that's a
just for
separate
the
thing that you
property.
already talked about.
Yeah. And that is after
Yeah.
the end of the lawsuit, and it's still you have 1 year period.
Okay.
dava açmaları, yabancıların dava açmaları, Türkiye'de dava açmaları milletler arası özel hukuk kuralları çerçevesinde tabii ki belli koşullara vardır. Ama bulunduğu ülke koşulları açısından bu teminat gerektirip gerektirmemesi konusundadır dava açmada. Dava açma hakkının olduğunu engelleyen bir durum değil. Teminat evet.
Under the Turkish law, the non-citizens have only a limitation with towards the money that they have to put into escrow when initiating a lawsuit, but nothing. There's no limit for non-citizens to initiate lawsuits.
Ülkeler arasındaki bu anlaşmalar birçok ülkeyle Türkiye arasında yapılmış. Bulunduğu ülkeye göre bakmak gerekiyor.
And as for the amount that should be put into escrow, Turkey has many dual and multiple international treaties that have lifted this requirement.
Kelly Hogan has another interesting question. Would your firm be open to filing a class suit on behalf of numerous plaintiffs without deed information, seeking as a remedy the government municipalities taking the initiative to review archives to locate previous minority individual owners? So class action lawsuit.
Toplu dava açmada ilgilenir misiniz? Mesela hep beraber dava açalım. Arşivleri, bütün herkesteki arşivleri açsınlar, yapsınlar, bunları inceleyelim, kendi şeylerimizi bulalım diye dava açmaya musunuz?
Ferdi de olabilir, kişisel de olabilir, toplu da olabilir yani.
It can be
neticede-
as that.
Do you think the class quality is going to give more of a, airtime, PR, all sorts of things?
Açılırsa bu davaların
Yok, baskıyla ilgili değil. Sizin bulacağınız delillere göre neticede yargılama yapılacaktır.
So that kind of a lawsuit can be initiated individually or as a class action, and it won't matter if it's a class action or not. It matters what kind of a proof we have.
Last question is going to be Moses Karaguzyan from here. Is it possible to research the property titles registered between 1915 and 1920, during which time properties were reallocated and or confiscated? Because this will help to identify the properties that were transferred illegally.
1915 ile 1920 arasındaki arşivlere ulaşabiliyor musunuz?
Bazı bölgelerde ulaşabiliyoruz, evet.
In some areas, yes, we are able to reach.
I have a follow-up question myself on citizenship issues. I mean, I remember having read in Taner Akçan and Ümit Kurt's book, The Spirit of Laws, about the very cumbersome process during which Armenians who left after 1926, I believe, have been stripped of their citizenship, and that was not sort of reverted back to its original status. So what would be the status of those Armenians and their heirs whose citizenship have been stripped of them in an extremely illegal way because they were not let in by the sheer fact of they were controlling the borders, and they were not even let from the borders to get in, so that they cannot claim their properties. But what is the citizenship end of it, you know?
Vatandaşlık ayrı bir husus yani, çünkü o kaybedilen vatandaşlıkların nasıl kaybedildiğini bilmek lazım. 1926 yılında işte yurt dışı terk ettiniz, gittiniz, burada değildiniz, tekrar ülkeye alınmadılar. Bu hususlarla ilgili herkesin o aslında özel bir durumu var. Yani hangi koşullarda kaybettiğine dair ve o koşullardan sonra muhtelif aflar geldi. Mirasçıların başvurması ya da vatandaş olmak isteyenler. Değişik vatandaş olma çeşitleri var. Onlara herkesin özel durumuna bakmak gerekiyor.
So, and that topic is about citizenship, and it's a separate topic. And because each family's history is different from each other, in each of their citizenship has been lost in different ways, we have to look in different cases.
Yani özel durumuna bakacak. Koşulları var mı yok mu onu bilemeyiz.
We
Çok genel bir şey
we need
söylemek
to
değil.
check if the conditions are met. Oh, there have been some laws enacted in the 100 years that actually gave the option to the heirs to come and reclaim their citizenship. So we have to make sure that they are also qualified.
Okay, şimdi çok çabuk yapacağım.
Evet.
I have a question. Pre-World War I or pre-genocide, are the real estate records available and open to the public, and especially in Harpert, Mamurat Elaziz, Elazig, that region?
Şimdi özellikle son 4-5 yılda Türkiye'deki bütün arşivleri Ankara'ya taşıdılar.
So they moved all of the archives to Ankara in the last 4-5 years.
Yani geçmiş dönemle ilgili Elazığ ve Malatya, o bölgedekileri bulunup bulunmayacağını bilmiyorum ama tabii elinizdeki evrakla ancak o belgeye ulaşma imkanınız söz konusu olabilir. Yoksa gidip aradığınızda bulmanız mümkün değil. Tonlarca, milyonlarca defter var.
There are billions of documentation in the archives in Ankara, and you need to have a lead to actually go and find your way among the archives.
Preferable to have some kind of
Yes, it is preferable.
What percentage of the Armenian foundations and institutions have initiated lawsuits or administrative actions to recover properties? And how many are there? How many Armenian institutions and foundations are there, if you happen to know?
Oh,
If not,
54 foundations.
there are 54 foundations.
Yeah. And
And-
how many of them have initiated?
And is it only foundations that have the own properties, or are there other institutions outside of foundations that also can own properties?
Vakıflar haricinde bir şey var mı? Başka şirketler veya kuruluşlar var mı? Azınlık vakıflarla şeyleri azınlıklarla ilgilenen başka dışında başka kuruluşlar var mı diye.
Yani azınlık vakıflarına bağlı, o cemaatlere bağlı dernekler var. Türkiye Cumhuriyeti kanunları çerçevesinde kurulan.
There are some associations that are connected with the foundations that is working with the foundations, under the foundations.
Bunlardan kaçı
I just put the info as a slide because there are multiple people asking the same question. So please take the contact name, numbers and emails from this one.
taşınmazları için başvuru, idare ederler kısmı başvuru yaptı diyor.
Yani hepsinin çok sağlıklı bir çalışma yaptığını söylemek güç.
It is hard to say that all of the foundations are doing the work that is needed to be done under the restitution rates.
Yani yasal düzenleme yapıldığından en son yapılan düzenlemeden 10 yıla yakın bir süre geçmesine rağmen halen hiçbir iş yapmayan vakıflar var.
There are some foundations that have not lifted a finger in the last decade that these restitution laws have been enacted.
And was the Surpagop Hospital
Right across.
compensated for its loss of, I think, a cemetery? Have they received compensation? It was a question. Yes.
Parasını aldı mı?
Hayır.
No.
No?
No.
Hayır. No, they have not.
Onunla ilgili işin kimse bir başvuru da yapmadı.
No one actually initiated a lawsuit for that cemetery.
Orada bir
That's why
mezarlık duruyor ama
there was no claim, there's no result.
Up until very recently, the tombstones were still photographable. I have a friend of mine who took the pictures prior to the 2013 Gezi events. So there were
Yani-
like tombstones
Evet.
around.
Bir şans var mı diyor.
So I would like
course.
to thank all of you here in this hall and also our Zoom guests. Thank you very much for your interest. You can follow up with them in person. So I put up the contact names, numbers, and emails. So that's the end of our program tonight. I
Yes, it
believe.
is.
Thank you, Ara.
Thank you,
all.
Aida.
Thank you.
Thank you, Destina. Thank you, Mayor. Thank you, everyone.